P.K. Rai Chaudhary is out of station, my lord. So some accommodation, my lord. On Thursday, my lord. On 19th, my lord, kindly. take
From
up
the other side.
other side, my lord, he is.
May I please your lordship, my lord, let the item be reached and then your lordship may consider it, because it was that in between 10:06 or 10:09 of the interpretation, your lordship fixed it today. My lord,
He has got some difficulty, we'll have.
my lord, only thing is the
Only
bank
it will be
account.
for today,
My
my
lord,
lord.
only thing is the bank account closed, and day after tomorrow is the lifting date. They will literally kill me, my lord. If I say I'm the president and I cannot lift at this juncture before Eid, if I can't lift the items only.
So how do you accommodate him? He has some
My
difficulty.
lord, for today, my lord.
Can I wait tomorrow?
Tomorrow, my lord.
Tomorrow we'll have it. Tomorrow. You're caved in.
Caved in.
Caved in learned counsel for the respondent number 5 has prayed for an accommodation on behalf of Sri P.K. Roy Chaudhary. Full stop. The prayer, however, has been opposed by Sri J. Abedin, learned counsel for the petitioner, as well as you are also opposing.
Yes, that's number 4.
As well as Sri D. A. Kayum, learned counsel for the respondent number 4. Para. Considering the above, a slight accommodation till tomorrow is granted. List tomorrow.
Obliged. Deeply obliged.
But these two matters may be listed for motion tomorrow.
Motion,
Which.
Happy, your lordship. I recommend item number 18, your lordship.
Item number
18, your lordship.
18.
Yes, lordship. Lordship, leading counsel, Mr. T.J. Manta, said some difficulties with your lordship. His father death ceremony is today, your lordship.
16 matter, okay. Personal difficulty. When can we have? Day after tomorrow.
Not day after tomorrow, your lordship. Next week, any day, your lordship.
Okay, next Tuesday.
Lordship. Yes.
On a request made on behalf of Sri T.J. Mahantalan, Senior Counsel for the petitioner. Matter is adjourned to be listed on Tuesday next date.
Obliged.
May I please, lordship? My lord,
Yes.
the applicant filed a writ petition, lordship, challenging his disqualification order as Panchayat member, lordship. The honorable court directed for.
What is your prayer? We are
Lordship, I
telling
have
some
filed-
history. We are not interested in your history.
Lordship, I have filed an IA for compliance of the judgment passed by the.
Fresh eye. Fresh eye. Has it come for
Lordship,
consideration?
fresh IA.
When do you want?
Lordship, on Wednesday, Lord.
Wednesday is tomorrow.
No, next Wednesday.
Okay.
Obliged, Lordship.
Can move it on Friday also if you want.
Lordship, Wednesday, Lordship. Obliged.
Yes, madam.
Your lordship, I beg to mention item number 20 on the daily list. Your lordship, the lead counsel is out of station for prefix matter.
Yes, madam, this matter, as you know, we are not, don't make a mention now. Let it reach.
Your lordship may have it on Thursday. The lead counsel is out of station. I don't have instructions to argue this matter, your lordship.
Let it reach. Let it reach. We'll see.
Yeah, please, your lordship. I beg to mention item number 17, lordship.
17 refused.
Lordship.
Your application, your prayer is refused.
Lordship, actually, my senior SG Gauhati went to the zero Arunachal Pradesh because of weather she could not reach Gauhati on time.
We refuse. 2015 matter.
Lordship,
Sorry.
on Thursday.
Sorry. Next.
Beg to mention for listing of motion matter tomorrow, Lordship.
Lord, similar motion.
Yes. Motion is.
Motion matter, my lord. Motion.
Motion is.
May I please, Lordship? With the consent from the other side, Lordship, I beg to mention item number 12 for adjournment.
12.
Yes, Lordship.
You're on behalf of whom?
The goes, that's it.
The Ghosh.
Yes, Lordship.
That's the number. On a request made on behalf of Miss D. Ghosh, learned counsel for the petitioner. Matter is adjourned to be listed when?
After 2 weeks, Lordship.
After, why 2 weeks?
First week, she will be out of station.
Matter adjourned by 2 weeks. Put the list on. We give a date. Today is, I think, 17th. On the 1st of April.
Deeply.
1/4. Yes.
May I please, your lordship? I beg to mention for listing of a matter in orders on some petition, your lordship.
Contempt orders, what urgency?
My lord, maybe on 27.
Sorry, Don't make a mention.
Related to pension, your lordship. I have
Doesn't,
only-
contempt, what do you get? Sending somebody to prison. If it has it been a writ petition, we'd have allowed. Sorry.
That's the direction of, in the writ petition.
You filed an application before the registry. Yes.
Happy to lordship. On behalf of NSIK, I beg to mention item number 19, my lord.
19.
Yes, my lord.
Yes.
This is for hearing, my lord, and for the last 2 to 3 occasions, the matter did not even reach because of positive time.
Okay.
And say humble prayer that this matter may kindly be taken up at 2, my lord.
We cannot upgrade it above the orders and admission. Hearing, we can see if we take it as the first hearing. Okay.
Proceed. Obliged, my lord.
May I please, your lordship, in item number 13, lordship, we have filed affidavit in opposition yesterday, but it is not on record, lordship. The record may be called.
You bring it? Okay.
My lord, I am sorry that fresh IA, can it be tomorrow, lordship? Tomorrow, fresh IA, lordship.
Tomorrow, yes, you can have.
Obliged.
I think 25 to 31 for me.
My lordship. Lordship, I have a good day ahead, lordship. Lordship, with due respect, lordship. So here inadvertently, lordship, I have mentioned only the item number 25, lordship. So inadvertently, lordship, item number 26 to 31, lordship, is a wrongly listed, lordship. I have approached before the registry, lordship. Registry says it's a bona fide mistake, lordship. So I have only the item number 25 for withdrawal with liberty to file a fresh, lordship.
And others will remain.
It's a wrongly listed, lordship.
Okay. Madam,
In
25 will allow him to withdraw?
But liberty, it's a land compensation matter, my lord. So liberty may be a bit difficult for us. If later on he has claimed another amount, my lord.
Lordship,
That repercussion is there, my lord.
no doubt, lordship, is a perimeter matter, lordship.
Withdraw, but without liberty. Item 25.
What is the cause of action, Mr. Das?
So, lordship, whatever, so, lordship, is a cause of action, lordship, in regarding this land acquisition matter, lordship. So the perimetry matter, lordship, another the 7 matters. So, lordship, here in some mistake, lordship, in the pleading, lordship. So that's why, lordship, is a little bit correction, lordship. So if permit, lordship, so with liberty to.
Sri R.C. Das, Learned Counsel for the petitioner, submits that he has instructions not to press this writ petition. He has also prayed for a liberty. Puts the para. Miss M. Bourbon, Learned State Counsel, as well as who is for the water resource? Okay. On behalf of your standing counsel, R.M. Das, as well as Ms. Swins, Learned Counsel appearing on behalf of Sri R.M. Das, Standing Counsel, Water Resource Department, have, however, have submitted that though they do not have any objection on the, with regard to the aspect of withdrawal of this writ petition, comma, they have serious reservations on the issue of grant of liberty. A similar stand is taken by Ms. G. Hazarika, Learned Standing Counsel, Revenue Department, para. Under the aforesaid facts and circumstances, while this writ petition is allowed to be, is dismissed on withdrawal, comma, it is made clear that only on a fresh cause of action, the petitioner would be at liberty to approach this court. Full stop. In Baki Lekhiba, it is submitted by Sri R.C. Das that these cases were wrongly tagged with WPC 3097/2024, which has been withdrawn, which has been dismissed on withdrawal today, full stop. In view of the above, list these cases for admission
Yes, lordship.
after a week.
Yes, lordship. Much obliged, lordship.
In that case, my lord, that may be after vacation, my lord, because we need to file affidavit only. on this matter first.
After 2 weeks,
Yes.
In the meantime, the respondents may file their affidavit in opposition.
Yes, lordship. Much
We
obliged.
give a date, list on 22nd of April.
Yes, lordship. Much.
2 weeks, talk about this after the vacations. Item 32. Yes, item number
Eviction from Patta land, my lord. My lord has dealt with,
30.
my lord has dealt with similar matters, my lord. So since 1982 by virtue of a registered sale deed, my lord. Okay. Now read. The impugn eviction notice.
In tribal belt,
Tribal belt.
how could you purchase land?
Yes, yes. So, my lord, land was purchased in the year 1980. Now, my lord,
How could you
one
purchase?
One of my grounds, my lord, if my lord paid.
No, first you have to answer one question.
Yes.
How could you, are
Yes.
you a tribal? You are not a tribal.
No,
How could you purchase land in a tribal belt
Yes.
in 1980?
my lord,
Don't you think that the transaction is void ab initio?
may not be in certain cases.
Why?
My lord, I have taken the stand, my lord, the petitioners before your lordship, they belong to the Goria community and who are the permanent residents of the area in the Mozas of Jalukbari and Dokhin Rani, my lord. From a very long time, they've been
So are you
residing there.
tribal?
I'm not a tribal, but chapter 10 also carves out an exception for persons who are permanent residents, my lord. Now,
No, permanent residence, had you been a resident before the creation of the tribal belt and
Yes,
block,
yes.
matter is different. You cannot be evicted. But
Exactly.
can you purchase land after
Yes.
declaration of the area as tribal belt and blocks?
My lord,
Question is that,
yes,
how could you be given permission?
chapter 10, my lord, it says.
Yes,
my-
I've seen chapter 10.
Yes.
Let us see what is
Yes.
chapter 10.
uh, 164, if my lord takes up 164.
Yes.
164, 2 my lords, there are two provisos. May I read my?
Yes.
A landholder shall have a right to use and occupancy in the land held by him, subject to any restrictions and modifications prescribed in rules made under this chapter and to the provisions of section 9, provided that no landholder shall transfer his land in a belt or block to any person not belonging to a class of people notified under section 60, tribals, my lord,
160.
one tribal
Hmm.
B, to any person who is not a permanent resident in that belt or block. So there can be transfer to a person who is a permanent resident, my lord. If my lord reads the proviso, provided further that no such landholder shall transfer his land in a belt or block to any person who is a permanent resident in that belt or block and who does not belong to a class of people notified under section 160, except with the previous permission of the deputy commissioner. Now, provided also that in granting permission, the deputy commissioner shall have due regard to the interests of persons belonging to the classes notified under that section. my lord. Now, when in my humble submission, my lord, when the sale deeds were executed in the year 1980 and thereafter it was mutated in the names of the petitioner, my lord, there was a permission taken, my lord. And that permission,
Do you have the permission?
I don't have the permission. That permission should be deemed.
See,
my lord.
we have
Yes.
entertained these matters, these kind of matters. We have also granted some interim protection.
Mm.
But we are going to
Yes.
issue a direction
Right.
to cause an inquiry how these were granted.
Yes.
And if it was granted
Yes.
in the course of the law, then
Yes.
those
Yes.
officers, they'll have to be taken
Yes.
to task.
So if I can procure the permission, that would, if
See,
that's
the
the only way-
entire objective of having a belt and block
Right.
is to secure it, to preserve.
Right.
Now, there are provisions which you have pointed out. We have seen this provision. See these stringent measures.
Yes.
If it is a non-tribal and he has to be a permanent resident, even if that case, special permission is required, which is not required in
There has
other
to be an
cases.
Inquiry, my lord, whether I'm
Difficult. We'll
I'll
follow
also
that
try-
order. We'll
try
follow that order, but heard. P. Mahanta, learned counsel for the petitioners who are aggrieved by an eviction notice dated 27/2/2026
page 58, my lord.
issued by the circle officer,
Yes, my lord.
Azara Revenue Circle.
Azara Revenue, sir.
Full stop. The contention advanced is that the land in question was purchased by a registered sale deed in the year 1982 by the father
Father, my lord.
of the
Petitioner.
petitioners. And therefore, the impugned notice cannot affect the petitioners. Full stop. Para. On the other hand, comma, both Sri N. Goswami, learned State Council, and Ms. P.R. Mohanta, learned Standing Council, Revenue Department, have contended that the land is a part and parcel of the tribal belt and blocks, which is protected under Chapter 10 of the Assam Land and Revenue Regulation 1886. Full stop. They have also contended that admittedly both the vendor and the vendee are not tribal, who are protected under the aforesaid provisions. Full stop. Para. Sri Mohanta, the learned counsel for the petitioner, has referred to Regulation 164 of the Regulation of 1886 under Chapter 10, as per which, though there is a bar for transferring land to any person not belonging to a class of people notified under Section 160, that bar is not applicable to any person who is a permanent resident, with the further requirement that previous permission from the Deputy Commissioner would be necessary. Full stop. There is a further proviso that in granting such permission, the Deputy Commissioner shall have due regard to the interest of the persons belonging to the classes notified under that section. Full stop. In the instant petition, from the instant petition, from the pleadings and the documents enclosed in the instant petition, it is not discernible as to whether the aforesaid provisions have been complied with or not. Full stop. Para. Be that as it may, let notice be issued, returnable on 30/3/2026. Miss P.R. Mohanta, one, madam,
Yes, it's no one.
one,
I'm 226.
226, and Goswami. Extra copies. Sri Mohanta, the learned counsel for the petitioner, praised for an interim order, which, however, has been seriously objected to by the learned counsel for the respondents. Para, considering the facts and circumstances, and also the registered sale deed of 1982, it is provided that till the returnable date, no coercive action for so and so. Huh?
I'm at serial number 199. There are a lot of people.
In that serial, okay.
Serial number.
In that,
Annexure
okay,
notice. There's an annexure, my
it
lord.
is made clear that the present, this is there. So it is made clear the interim order parties to the petition.
It's not affected so far.
Back or other. Deeply obliged, my lord. Very grateful.
Order dated. Land with legal goods. In the petition number 1451/26.
Those were pertaining to registered sale deed?
No.
Perhaps
No,
no.
my lord.
No, part of it only those who have dismissed. Those who have dismissed. This is the case of registered sale deed. So, but we will go to that extent also, because these are matters of immense importance for the state. Okay.
Deeply obliged.
33. List along with 33. List along with 1455 of 2026. অল্প on করে দিয়ে পিছত দিব পাৰো receipt টো।
Maybe. But there are two writ petitions before your lordship.
These two matters have a long and checkered history, my lord. Facts are kind of long. Before I take your lordships through the facts, if your lordship permits me, I can give a brief summary of the.
Yes, please. We take up which one? 5943?
The first item, my-
5943.
That has all the facts.
Okay.
Lordship, if it is not too inconvenient for my senior,
Yes.
can this matter be taken after some time? Because Mr. B. Gogoi will be leading this matter.
But we'll
Both
take
the
it up today itself. These are old matters. After a while.
This will take some time.
Hmm.
In that case, my lord, I can complete my part because there are some other matters also. So
It can be done, but.
my friend Mr. Gogoi can respond at a later point.
Just wait, let's wait for around 10 minutes. If he doesn't come, we'll start. Okay? Maybe one more matter in the meantime. Ask him to come by around 11:05.
Lordship.
May I please, lordship? My lord, our case is that we have purchased 1 biga out of 8 biga 3 katas land. By one sold it.
You purchased what?
1 biga 3 katha.
1 bigha 3 katha.
I've got a report from Secretary BTC. I'll place it by way of affidavit, Lordship. Can it be given, can it be?
What is that report?
This is a report received by Circle Officer Dr. Mar Avenue Circle in connection so and so. Lordship, as regards Lordship area and DUG number of the land and Lordship field verification report is there of the Circle Officer. And copy of the sketch map, your Lordship. Cheetah.
Okay, Mr. Mahmood, let her put this on affidavit. But short time. The matter is of 2022. Yes.
But in this case, we are appearing on behalf of the respondent number 8 and 9.
Who are 8 and 9?
8 and 9, my lord, private person, landless people. They have been, my lord, allotted the land, which is disputed by my learned senior friend, my lord. Their land absolutely different from our land. Now, under the color of the sale deed, my lord, they are trying to occupy our land. Now, this land, my lord.
You filed affidavit.
My lord, I have filed.
Okay, we'll consider your case. Let them file the affidavit.
Respond. And with the same land, we had absolutely different plot of
Heard
land.
3 M.U. Mahmood, learned counsel for the petitioners. Also heard Miss B. Bhuya, learned senior counsel, appearing for the BTC. Puts up 3 BKs and learned counsel is present for the private respondents.
We are as legal aid counsel.
BK, learned legal aid counsel has appeared for respondent numbers
8 and 9.
8 and 9 and has submitted that affidavit in opposition has been filed. Clara? Ms. Bhuya, the learned counsel, learned senior counsel has submitted that certain written instructions have been received from her clients, which she would like to put on record by way of an affidavit, for which she prays for 2 weeks' time. We'll have immediately after the
Holidays?
After the Bihu vacation. List on 22nd of April 2026, by which time the affidavit is required to be filed.
Instruction reports, written as report, nothing has been started by then. Only report is
They
given.
received a report. No?
My lord, the question of maintainability may kindly be kept open because, my lord,
Now,
my lord, it appears that
Mr. Sen, this prayer
my lord.
would have been considered in the year 2022. In 26, maintainability we cannot observe. We'll definitely argue on the maintainability part.
My lord.
We are not stating that it be kept open. We'll definitely consider. Make your arguments.
My lord, as it appears from the facts, purely disputed question of facts.
Okay,
Yes.
okay,
Whether your
we'll
lord
consider your case.
26, my lord, that is.
That will be your defense. Let us see.
My lord.
Okay, next.
I am deeply obliged.
22nd column, no?
Till 4 and 5.
My lord, in these matters, Mr. Goyal is appearing. He is on legs in court number 2, my lord. It may kindly be taken up in the next week, my lord.
What are these matters, Madam Sharma?
Matters lordship, we had issued some notice, railway
Demand
for
notice.
demand notice were issued. Our case is that for those land, there was no revenue was paid. And now they are relying on a judgment of, but our case is that it is not on the same footing. So we are not covered by the said judgment lordship. In the second case, I have also raised the question regarding maintainability because on the point of jurisdiction as well as there
Okay,
is-
next week when?
After 24th, my lord. After 24th of March.
Then 26th?
26th, my lord.
We're trying on 26th? Or maybe 31st, whenever you say.
31st, lordship 31st then.
Okay, a prayer for adjournment has been made on behalf of Sri A. Goyal, Learned Counsel for the petitioners. Miss B. Sharma, Learned CGC is present. Para. As agreed to by the Learned Counsel for the parties, matters are adjourned to be listed on 31/3/2026
Obliged.
for admission hearing.
Item 6.
What is the matter? State of Assam is a petitioner?
Yes, Mr. Lordship, this petition has been prepared as selling the inaction on the part of the principal chief conservator of forest and the head of forest force Tamil Nadu Lordship in facilitating the return of an elephant. Her name is Jaimala Lordship to state of Assam, the original state Lordship. That is the basic reason, Lordship, why this petition has been prepared.
Tamil Nadu has appeared.
Yes, they are appearing, Lordship.
Your lordship will permit me by appear by VC.
Is there any dispute? Is
Correspondent number
there
11.
any serious difficulty?
Where the
There
elephant
is,
is.
because the state of Tamil Nadu is asserting its legal right over the elephant. The state of Assam has a contra claim over the elephant. So far as my lord, leaving aside other issues, there are two pertinent things I would like to mention at the very outset. First of all, my lord, in respect of the captive elephants, all the issues pertaining to captive elephants, the Supreme Court had constituted a high-powered committee that was pursuant to the judgment of the Tripura High Court. Subsequently, my lord, in two subsequent cases, the Supreme Court extended the very jurisdiction of the high-powered committee, which is to look into the issues pertaining to captive elephants. The first case being MS Murli case, followed by Bendra's case. Now, the terms of reference of the high-powered committee, my lord, includes the present issue also. Namely, as to whether elephant has to be shifted or not shifted. If it is to be shifted, where it is to be shifted. So, my lord, the Honorable Court wanted us to obtain an instruction as to what is the stand of the state of Tamil Nadu in respect of the referring the case to the high-powered committee.
Correct.
So, my lord, I wrote to the state of Tamil Nadu, my lord, and they have given their consent. They have very well passed an order. They are agreeable to refer this matter to the high-powered committee. The order is also, my lord, is there in the record. I had given the copy of that order. So, my lord, this is first part. Now, the second part, my lord,
Is the
when the
state of Assam agreeable to
state
that
of Assam,
proposal?
it seems, my lord, apparently, my lord, on the last occasion, so far as I recall, the London Advocate General said we would like to argue on merit and we are not keen. But the question is, my lord, there is not their keenness. If there is a high-powered committee to look into all these matters constituted by the Supreme Court, and this is what the Supreme Court says, then, my lord, the state of Assam doesn't have any choice. That is one part of the matter. Now, the second part of the matter is, my lord, when the whole controversy blew up in 2021, because Jaimala was to be, as per the original condition, between the respondent 7, the Green Moran, who is the holder of certificate of owner of Jaimala, there was this agreement between the state of Assam and Green Moran, respondent 7. As per the agreement, Jaimala was to be in the Shia Temple, Tamil Nadu for a period of 2 years or 3 years. She was to come back to Assam in September 2013. That did not happen in 2013.
13 or 23? 21.
2013.
13.
2013.
It
So,
happened
my
in
lord,
expired, they kept on sleeping over it. In 2021, one NGO called FIPAO, it raised an alarm that Joymala has been treated. It came out in newspapers over here. So all hell broke loose. So, my lord, over here, then the government of India also wrote to the state of Tamil Nadu as to what is happening to Joymala. Tamil Nadu clarified everything. One particular Mahavat was there. He was also dismissed from service. And then Tamil Nadu government took over the entire matter. Periodically, doctors are going. Joymala is absolutely hale and hearty, very healthy. Proper treatment, everything is there, my lord. So periodical medical reports are also there, which are part of the record. During that period, my lord, when the state of Assam started taking initiative in 2022, after 8 years, that, well, Joymala should be brought back, an inquiry was made in respect of another elephant also, someone called Lakshmi. Actually, my lord, in Tamil Nadu, there are more than 20 captive elephants. So far as the state of Assam is concerned, 9 captive elephants are confirmed. So at that point of time, my lord, in 2023, a PIL was moved in the Madras High Court in respect of the 9 captive elephants from Assam. Joymala was also included over there. So they wanted a writ of mandamus before the Madras High Court.
It was moved by whom?
My lord, it is moved by, my lord, possibly they are the temple of order copies also there.
Okay.
Group of people. Possibly they had their vested interest in the elephant.
In Tamil Nadu?
In Tamil Nadu, Madras High Court. Because those 9 captive elephants are in the Tamil Nadu itself.
Okay.
So they moved the Madras High Court saying that let there be a writ of mandamus to the state of Tamil Nadu that these elephants in Tamil Nadu will not be sent back to Assam. Because these talks were going on. At that stage, my lord, we all know what happens in such situation. So, my lord, the state of Tamil Nadu
We do not know. You may know, we do not know.
So, my lord, order is there. Order is there.
Don't use the expressions like we.
Very well, my lord. Whatever. I'm sorry.
Say, I know.
Very well, I'm sorry. So, my lord, what happened was, the state of Tamil Nadu gave an undertaking to the Madras High Court that those 9 elephants will not be handed over to Assam, including Joymala.
There was an order.
That it's part of the record.
Okay.
It's included in the order. So these two are the important aspect of the case. Now, my lord, so far as other issues are concerned, I'm raising an issue of maintainability, bringing in Article 131 Clause C of the Constitution, because apparently the legal rights of the contesting states on Joymala
Why don't proceed and sort out the matter? Is it so difficult? Two states are
we are willing to, my lord,
two
we have
states are
agreed.
involved. It's not a dispute between private persons.
We are basically concerned, Lordship. Initially, one NOC was issued by the Tamil Nadu government for returning the elephant.
Okay.
For which, Lordship, if Lordship comes to page 55, Lordship.
Then thereafter?
Then they said, you deposit such and such amount so that elephant can be returned. We informed them, Lordship, that we are ready to pay 5 lakhs rupees. That is at page 66, Lordship.
Okay. Then?
In spite of their Lordship, subsequently they changed their mind, Lordship, and now they are not returning, Lordship. That is the only issue we have at this moment, Lordship. As per court's direction, our team went there, inspected the elephant. It is found to be in a good condition.
What about the order in the PIL by the Honorable Madras High Court?
In that case, Lordship, we are not party, Lordship.
But that would be binding if those.
The binding is there, Lordship.
If there is an order not to transport.
That is there, but Lordship.
How do you overcome that?
Lordship, it is Lordship will see a case, Lordship, wherein Lordship, we are claiming the ownership of the elephants, Lordship, being the state. But we are not heard, Lordship. An order was passed.
No, if you have not heard, can you live like that? You can either file an appeal by seeking leave, whatever you want to do. We are not here to advise.
State government is also looking after that.
But won't that order be a stumbling block in the adjudication of this process?
Yes, Lordship.
Rightly or wrongly, there is an order.
Yes.
Maybe it was not passed after giving you an hearing, but there is an order we cannot overlook. Now, this order is also known to you. You have means to seek remedy against that order. Either you, whatever you do, get a clarification.
Lordship, in fact, if Lordship comes to the order, Lordship, at page 227
of this
is not an, I mean, no such direction was there. It was an undertaking given by the authority, Lordship. If Lordship comes to page 226, Lordship, 226 of what? Their affidavit in opposition, Lordship.
Okay.
226, paragraph 4, Lordship, down.
226.
Yes. Paragraph 4, Lordship. At the bottom, Lord.
Yeah, in view of the
In
submission.
view of the submission made by the learned advocate, additional advocate general to the effect that the respondents are not going to send back the temple elephants to Assam, and that the respondents would take care of the temple elephants in the best possible manner, we do not find a reason to give any further direction to the respondents to take care of the temple elephants.
Okay.
So
No, there was no restriction. as such.
ultimately, no such direction was there.
No direction
It was
as
only a
such.
undertaking given by the state
Only
authority.
to take care of those elephants.
Yes.
Nothing to do with the aspect of
Nothing more than that,
transportation.
Lordship.
Okay.
So far as the, I
So
mean,
that order will not come into the way of
yes,
adjudication of this process.
that is the understanding. So the facts remains, Lordship. Initially, they agreed. They are granted NOC, Lordship. They ask us to deposit a certain amount of money. Given our accent, yes, we are ready to deposit that amount.
Then where is the requirement to send this to a high-powered committee? There is no dispute.
Yes.
There is no order of the High Court of Madras of restriction.
Madras Court did not refer. back to the
You
omnibus.
asked for an NOC. They said yes, we are willing. Now where is the dispute?
My lord, the dispute is, my lord, it's not, initially, my lord, it is true, we agreed. But subsequently, my lord, ultimately, governments, my lord, they have to listen to their people also. So from the temple authorities, temples have huge following.
No,
over there in
we'll
Tamil
decide
Nadu.
in accordance with law. We will not go
In
by
accordance with
emotion.
law. That's why, my lord, now they're talking about law. Initially, they agreed because now, after 8 long years, such a demand came from Assam. Now, Tamil Nadu has taken a stand that we go legally. Either we refer the matter to the High Power Committee and we are agreeable because High Power Committee is constituted by Supreme Court. It is in session of all these cases.
The High
of
Power
captive
Committee is, what is the purpose of the High Power
High Power
Committee?
Committee issues pertaining to captive elephants in general.
We are not on the captive elephant issue. We are on the issue as to whether the elephant is required to be transported back to Assam. That is the issue.
My lord, then, my lord, I'll argue on merit.
So that is the issue.
I'll argue on merit.
Nothing more than that.
I'll argue on merit. my
It's
lord.
not that a difficult case.
I'll argue on merit, my lord, in that case.
Yes, Mr. Naik. We'll decide this case. We have not started even the hearing.
Very well,
Get the opportunity. Let Mr. AG.
Lordship will dispose of today.
Yes, yes. That is not an issue at all to be. You don't need too much of time. Yes. What is it? Towards the NOC. So your
Lordship,
willingness to deposit?
Lordship, I am starting from page 54, Lordship.
5-4.
Yes. Line to continue into feet. তুমি ইয়াত পেজটো চাই যাবা কোনটো ক'ব লাগিব।
Yes.
This is page 4. This is letter dated
54.
54. Yes.
8/3/21.
8/3/2021. Lordship, may kindly see the subject. Request to return to Assam, Jaimala and Lakshmi, captive elephant held in the Nachir temple of Sri Villiputhur of Tamil Nadu, and to provide rehabilitation to the elephant registered. Sir, with reference to subject cited above, this is to bring your kind notice that during the recent past, 2 captive elephants, namely Jaimala and Lakshmi, presently stationed at Nachir temple of Sri Villiputhur in Tamil Nadu. It has been alleged that the captive elephant Jaimala, it was subsequently, or Jaya Malayatha, it was subsequently name, her different name, Lordship, have been held captive in the said temple in Tamil Nadu for last 13 years, and the person responsible for upkeep of the elephant have been very brutal to these elephants, such as regularly hitting them with sticks, etc. Moreover, the captive elephants have overstayed the period of stay in your state and have not reported back to Assam. While we are initiating action against the owners of this elephant for violation of the Wildlife Protection Act, it is requested that action may also be initiated at your end against the individuals, organizations who are the custodian of these elephants in your state. In this regard, you are requested to facilitate the return of these captive elephants, Joymala and Lakshmi.
It is not confined to one elephant, two
No,
elephants.
it's two elephants.
Okay.
The Lakshmi, for this particular letter has two elephants. Lordship.
Okay.
So far as the petition is concerned regarding one elephant. From Tamil Nadu to Assam, once NOC issued by you, we shall organize to bring the elephants back to Assam. Next page, Lordship, which is another letter, Lordship. This is dated 15/7/2021, page 55. Herein, they have again been requested, Lordship may come to the last paragraph, therefore it is requested once again to facilitate return of the captive elephants, Joymala and Lakshmi, from Tamil Nadu to Assam by issuing NOC without further delay.
Yes.
Page 56 is the NOC, Lordship. This is dated 12/11/2021. This was intimated by Dr. Sekhar Kumar Niraj, IFS, Principal Chief Conservator of Forest and Chief Wildlife Warden, Pangal Maliga, Srimad Chennai, Lordship. If Lordship comes to the page number 59, relevant portion, Lordship. Okay, let me remain at page 56, Lordship. Lordship, may kindly see the first paragraph. With reference to the above, I wish to inform you that the following 9 captive elements, including Joymala, Jetmala, have been transported from Assam state to Tamil Nadu and being maintained by the temples and
private persons.
Private persons. The details of are follows, Lordship. First one is serial number 1, Lordship may kindly see at serial column number 4, Lordship, name is there, Joymala. And if Lordship comes to page number 59, paragraph number 2, down below. In these connections, you were requested by reference first cited to inform the details of ownership certificate and transit permit issued for the above elephant, and the details are yet to be received. However, validity of the ownership certificate and above elephants were expired and the captive elephants being kept by the temples and private persons beyond the transit period. Hence, I hereby issued no objection for transporting back the captive elephants to the state of Assam. So this was the NOC. For I also request you. Next page, Lordship. I also request you to facilitate the return of the above captive elephants, including Joymala, and to take action against the owners of the captive elephants for not taking back the elephants.
Yes.
The next one, sir. Page 65, Lordship. Another letter from the Tamil Nadu Authority, Lordship. It is dated 26/4/2022.
Yes.
It reads, Lordship, with reference to your letter cited, I wish to inform you that the captive elements may be seized and taken back by the arrangements of Assam State Forest Department. I also wish to state that the officials from the Tamil Nadu State Forest Department will facilitate identification of the captive elements, present location of elephant, and details of present caretaker, etc. If the Tamil Nadu Forest Department has to accept your request of seizure and taking custody of the captive elephants, the cost of maintenance of captive elephants from the time of seizure till the handover of the captive elephants has to be borne by the Assam State Forest Department and to be paid before commencement of the seizure. I request early action in this regard. Next page is the reply, Lordship. Page 66.
Yes.
This is by the Principal Chief Conservator of Forest, Lordship, Assam. With reference to the subject and letter cited above, it is requested to kindly arrange to seize and take custody of 9 captive elephants at an early date. The cost of maintenance of the captive elephants till they are handed over to the Assam Forest Department shall be borne by this office as proposed by you. An amount of rupees 5 lakhs only is being paid in advance for 20 days, and the cost as per the actual estimate to be prepared by you exceeding the said amount shall also be borne by this office. Therefore, it is requested to kindly send official account with bank details for transferring the above mentioned amount in advance at an early date. So till that position, Lordship, it was okay, Lordship. Next one. Page 68 is, Lordship, the reminder, Lordship. It's an email message. This is dated 5th of September 2022.
Page
68.
Yes.
This is again to the Tamil Nadu counterpart, Lordship. Lordship, may kindly see the content. May kindly refer to the telecon of the undersigned with you today morning on the subject cited above. I requested, as requested by you, may please find attached in the trail email the set of documents correspondences from the Chief Wildlife Warden Assam, permission granted by the Chief Wildlife Warden Tamil Nadu dated 26/4/2022 to take back all the 9 elephants from Assam by way of seizure, and our subsequent correspondences requesting for bank accounts details to deposit an advance of rupees 5 lakhs only to defray and cost in seizing, securing and bringing to custody the elephants by the Tamil Nadu Forest Department and handing over to us in Tamil Nadu. In this regards, may kindly note that nothing much has happened in getting government clearance to bring back the concerned elephant to Assam, despite a large number of correspondences from our side since May 2021. Further, in the last few days, the pitch to get Jaimala and other elephants back to Assam has now become a public outcry, and our government is most determined to bring back the elephants at the earliest possible. As already discussed with you over telephone, I also conveyed to you the utmost concern raised by our Honorable Chief Minister Assam. I am under orders to send a team soonest to Chennai for health checkup and bringing back the elephants to Assam. May I request that once the Chief Wildlife Warden Tamil Nadu has agreed to allow bringing back of the 9 elephants to process of handing over the elephants in an amicable way may kindly be enabled from your side. I therefore earnestly request your good office to resolve the matter at the earliest and may kindly intimate the date when we can send team to secure the elephants. So this is a reminder. Next page, Lordship. 69.
Yes.
This is a team thereafter, Lordship, a 4-member team was constituted for the purpose of bringing back Jaimala and other 8 captive elephants which are held at various temples in Tamil Nadu and which were transported from Assam. A team with the following forest officers, police officer, and veterinarian is hereby constituted to discuss the matter with Government of Tamil Nadu, the Principal Chief Conservator of Forest and Head of Forest Force, Tamil Nadu, and the Chief Wildlife Warden, Tamil Nadu, for paving way for return of the captive elephants to Assam with immediate effect. Below are the 4 teams, Lordship, members of the team. The team will proceed to Tamil Nadu immediately. The team will discuss the matter with Principal Chief Conservator of Forest, Chief Wildlife Warden Tamil Nadu, the Principal Chief Conservator of Forest, Head of Forest Force, Tamil Nadu, and Additional Chief Secretary to the Forest Department, Government of Tamil Nadu, Chennai, on the basis of a copy of the documents enclosed herewith, and pave way for return of the elephants, including Jaimala, Assam. The team will visit all the places where the captive elephants are held in Tamil Nadu and assess their health condition. A report would be submitted to PCCF HOAFF Assam on completion of the visit of the team. Then if Lordship comes to page 75. Now the matter has been taken up by the Chief Secretary, Lordship.
Yes.
This is to bring our kind notice that there is a matter of 9 captive elephants brought from Assam and kept in various temples and other custody of Tamil Nadu. And further, there were media reports on torture caused to those elephants, especially one elephant named Jaimala. And the MOEF NCC Government of India took up the matter with the Tamil Nadu government, via their letter dated 1/3/2021. The Chief Wildlife Warden Assam took up the matter with his Tamil Nadu counterpart in right earnest, and after series of correspondences, the Chief Wildlife Warden Tamil Nadu gave no objection and agreed to return the 9 elephants to Assam by this letter dated 26/4/2022. I would further like to bring to your kind notice that the legal term of stay of these elephants in Tamil Nadu has long expired, and the captive elephants are long due for return to Assam. Meanwhile, the news of torture of Jaimala has spread all across, causing an uproar in the state. The sentiment of the people has risen high in favor of returning the elephant Jaimala due to repeated media report on her torture. The Honorable Chief Minister Assam has also raised utmost concern for immediate return of the elephants. The government of Assam has already sent a fact-finding team comprising of forest officers and experts to Tamil Nadu for verifying the elephants and assessing their health. The team has been camping there for the last 3 days. However, the team of officers are still waiting for the formal permission and cooperation from the government of Tamil Nadu for verifying the elephants and assess their health. Therefore, it is earnestly requested, please facilitate and to issue required permission for the team members to visit all the sites where the captive elephants are presently kept and examine their health to begin with. An early action is highly solicited in this regard. Next to. Next page, Lordship, another letter. This is 7th September 2022.
Email.
Lordship.
Email.
Email, Lordship, at page 76. This is again a request, Lordship, for not granting permission to inspect the condition of the elephants, Lordship, by the team leader. In continuation of our meeting with CWLW Tamil Nadu on 3/9/2022, there has still been no formal permission from the CWLW Tamil Nadu to visit the 9 locations. Today, I called up and spoke to him on the phone. The CWLW Tamil Nadu Sri Srinivas Reddy IFS informed me that they are still working on the response to our request of directing the local officers to facilitate the health checkup of the 9 elephants by our team. The team continues to stay at Assam Bhavan at Chennai from 3/9/2022. The undersigned is accordingly in touch with him and awaiting for the formal permission from the CWLW Tamil Nadu to visit the 9 locations and shall move immediately once the permission is accorded to him. So at that stage, Lordship, this petition was preferred, Lordship. Subsequently, Lordship, they were directed to file their affidavit, Lordship, they have filed, and what my learned colleague has stated, Lordship, that is the stand they have taken, Lordship. Now, the EIL filed by the Tamil Nadu, at Tamil Nadu Lordship and seen there, no order was there. It was only an undertaking given by the authority. In fact, this is a decision of the state government of Tamil Nadu, in spite of taking earlier a decision contrary. That is by granting NOC for returning the elephants, Lordship. So it was, as an afterthought, Lordship, they decided not to return. So that is the, at this moment, Lordship, this is the position, Lordship. Let him complete, Lordship, I'll definitely reply.
Yes, Mr.
Firstly, my lord, I'll make the legal submissions. The stand of the Tamil Nadu government is this, that unlike the wild animals, so far as the captive elephants are concerned, the state of Assam does not have a legal right over Joymala. Elephants, unlike humans, do not have a domicile. Now, the captive elephant, I'll elaborate my submission, my lord, a bit later. I come to the other points. First of all, my lord, the government of Assam is seeking the enforcement of the guidelines. That's my first submission. Government of Assam is seeking the enforcement of the guidelines of the Government of India dated 8/1/2008. This may kindly be seen, page 34. Page 34, the guidelines of the Government of India. These guidelines will not be prepared because prior to the guidelines, there was
Page 30.
Page 34 of the writ petition. Prior to these guidelines, my lord, there was no law in place regarding the maintenance, upkeep of the captive elephants. So, my lord, these guidelines were made in a meeting, my lord, wherein the chief wildlife wardens of all the states were present. Now, my lord, page 34, the important portion, my lord, will find at the very bottom. The matter was discussed in detail, the last para. The matter was discussed in detail with the CWLW of the states having major population of captive elephants. And it was decided that till states formulate their own rules, central government should consider issuing a guideline laying down norms for transportation, housing, feeding, vet care, and other norms for the states to follow. Accordingly, a detailed guideline for the care and management of captive elephant is being circulated. It is requested to such and such. Now, pausing here, my lord, I clarify. After this guideline, the state of Tamil Nadu made its statutory rules under the Wildlife, my lord, Wildlife Act of 1972, Wildlife Protection Act. That is the rule made under section 64, subsection 2F. So, my lord, now the statutory rules are in place so far as Tamil Nadu is concerned, and we follow our rules. The rules are known as, I'll give the copy to my lord, Tamil Nadu Captive Elephants Management and Maintenance Rules 2011. I'll give a copy. Lord, these are the rules. The rule 9, my lord, all the detailed guidelines are there as to how captive elephants are to be kept, etc.
But that is not the issue, Mr. Tiwari.
Explain that.
Kindly address on the issue. We are not on the captiveness of the elephant. We are on the aspect of transportation of the elephant.
Wherever.
Kindly address on that. That is the issue before us. We decide that issue.
Straight away, my lord, will come to the office order of
Page-
the government of
page-
Assam.
Yes.
Office order is 1510, but on the rule, one thing I'll point out, under rule 9, the captive elephant cannot move out of the state of Tamil Nadu without the permission of the chief wildlife warden of the state of Tamil Nadu. And in this case, my lord, he has chosen to withhold the permission. The chief wildlife warden. The rule 9 says that without the permission of chief wildlife warden, captive elephant cannot go. That is one part.
Page, rule 9.
Rule 9, my lord, of the rules.
What does it say?
Rule 9 says without the permission. Norms and standards of transportation, sub-rule 3. No elephant shall be transported to other states without obtaining a transit permit from the Chief Wildlife Warden, Tamil Nadu.
Yes.
Now, my lord, I'll come to the major issues. The office order of the government of Assam is dated 15/10/2011. Now, Annexure F, page 31 is the office order.
Page?
Page 31.
Yes.
This, my lord, will find that permission was given to Girin Moran to send the elephant to Tamil Nadu. Girin Moran is owner of the elephant. And that will be by subsequent submission, so far as the law is concerned.
Please read this, please read
It
this.
was up to 17/9/2013. That is the date. The last line,
Yes.
page 31.
Please read this.
My lord, actually, my copy is not clear. May I have your, because I
Okay,
can't
wait.
read.
In pursuance to the PCC of letter so and so, the female domestic and Joyamala, half of Joyamuti, with details below covered in this.
It's very bad.
Not to be transported.
Certificate number such as.
Go to-
Yes, my brother's copy is more clear.
Up to 17/9/2013.
Will be allowed to be
Okay, okay, up to 17/9. This is the permission.
Permissions till 17/9/2013. This is the date. Now, my lord, the certificate of ownership, my lord, will find certificate of ownership is affidavit of Girin Moran, 23, actually, 23. Yes, that is a certificate of ownership. It's a private property. Page 23 is the certificate of ownership issued to Girin Moran in respect of Joymala. And page 24 is also the 26/8/2011. That is a permission for a period of 3 years. Now, my lord, though Girin Moran took the permission, but what Girin Moran did, my lord, he also executed the gift deed, because captive elephants, my lord, can't be sold under section 43 subsection 1, but can be gifted. So Girin Moran, my lord, executed a gift deed in favor of Nashia temple. The gift deed, my lord, is dated 11/10/2011 at page 254 of the paper book. 254, it is part of our affidavit in opposition. I understand the Council of Nashia temple is present possibly. So anyway, 254, I'm just placing it. It's a gift deed. 254, 255. Elephant was gifted to the temple by Girin Moran. And my lord, gift deed is not under challenge.
What kind of deed is this? On a 10 rupee
My lord,
stamp paper?
but that's between them. It's a gift deed.
No, what is the
No.
legal entity of this kind of a deed?
My lord, that my lord, the council for the
No, no,
National Temple will explain. My lord,
I'm just
because
asking you,
my lord,
will it
has
have
come
any
to our
meaning?
notice. I have placed it. So I leave it to the other side to explain all this. But I'm just bringing it on record.
But there is a gift deed, that is
There is
a matter of
gift deed.
fact.
It's not under challenge, it's there. Now, my lord, I come strictly to the legal issues. Now, my lord, the first submission is that unlike the wild animal,
Yes.
my lord, within the meaning of section 2, subsection 36 of the Wildlife Protection Act, read with section 39. Lordship may kindly have my small note. For, please.
Wildlife Protection Act, which section?
My lord, section 39. Read this section 2, subsection 36. Lordship may have, may look at section 2, subsection 36 first. That is the property of the state in a given situation. I'll explain that.
36.
Section 2, definition clause, section 2, subsection 36.
Oh, 236.
Yes. Definition clause.
Wild animal.
Yes.
This is Wildlife Protection Act.
Such and such. Then Lordship will turn to section 39.
(72 to 236).
Wild animals to be government property. Now, my lord, 1A is important.
First you took us to 236, then?
It defines wild animal.
236, yes.
My lord, section 39 of the Wildlife Protection Act.
39.
Yes. 39 1A will be relevant.
39.
Every wild animal, 1A I'm reading, my lord.
Yes, please.
Every wild animal other than vermin, which is hunted under section 11 or subsection 1 of section 29 or subsection 6 of section 35 or kept or bred in captivity or hunted in contravention of any provision. So bred in captivity, if it is in contravention of any provision, that is not the case with Joymala. Joymala is bred in captivity, not in contravention of any provision of this act or any rule or order made thereunder, or found dead or killed by mistake, and others may not be relevant, then comes the state away, shall be the property of the state government. And where such animal is hunted in such a sanctuary or national park declared by central government, such animal or any animal, article, trophy, uncured trophy or meat, such and such, shall be the property of the central government. So in a given situation, it may be the property of a central government or the property of the state government. But it does not include within its fold captive elephant. Captive elephant without the certificate of ownership, then Lordship another, subsection 4. Subsection 3 first, section 39, subsection 3. No person shall, without the previous permission in writing of the chief wildlife warden or the authorized officer, B, transfer to any person, whether by way of gift, sale or otherwise, such government property, that is wild animal.
You are reading section, which one?
Subsection 3.
3. No person.
That is, since this is wild animal, so we are not concerned. Subsection 4. Where any such government property is a live animal, the state government shall ensure it is housed and such and such. We are not concerned, my lord. The entire submission is, it is not a wild animal. It is not covered by section 39. It is a captive elephant, which is, of which Girin Moran respondent 7 is the owner. An ownership certificate, my lord, was given to Girin Moran under section 40. I'll just place this also for my lord's consideration. Section 40, subsection 1 and 2 may also kindly be seen. And then certificate of ownership was issued under 42 because of the scheme of section 40, subsection 1 and 2.
40.
40. How Girin Moran got the certificate of ownership?
40,
that I'm showing.
40 is declaration.
Yes, because he had to declare. He had the elephant, baby, he declared it. Every person, section 40, subsection 1, every person having at the commencement of this act the control, custody or possession of any captive animal specified in schedule 1 or any animal, article, trophy or uncured trophy derived from such animal or salted or such as such animals, declare to the chief wildlife warden or the authorized officer the number and description of the animal or article of the foregoing description under his control, custody or possession, and the place where such animal or article is kept. Then subsection 2, no person shall, after the commencement of this act, acquire, receive, keep in his control, custody or possession, sell, offer for sale or otherwise, transfer or transport any animal specified in Schedule 1 or any uncured trophy or meat derived from such animal or salted such and such, skins of such animal or the musk of a musk deer or the horn, except with the previous permission in writing of the Chief Wildlife Warden or the authorized officer. Then my lord will come to section 42, certificate of ownership. That is how we got it, certificate of ownership.
Yes.
Section 42, the Chief Wildlife Warden may, for the purposes of section 40, issue a certificate of ownership in such form as may be prescribed to any person who, in his opinion, is in lawful possession of any wild animal or any animal, article, trophy, uncured trophy, and may, where possible, mark in the prescribed manner such animal, article, trophy, or uncured trophy for the purpose of identification, provided that before issuing the certificate of ownership in respect of any captive animal, the Chief Wildlife Warden shall ensure that the applicant has adequate facilities for housing, maintenance, and upkeep of the animal. Then, my lord, section 43, subsection 1 prohibits sale of captive animal. It can't be sold. Section 43, subsection 1, no person having in his possession captive animal, animal, article, trophy, or uncured trophy, in respect of which he has certificate of ownership, shall transfer by way of sale or offer for sale, or by any other mode of consideration of commercial nature, such animal or article or trophy of uncured trophy. So it can't be sold, but yes, it can be gifted. That is the standard position. So gift deed was made. Now, interesting part, section 43, subsection 2. After it is gifted or it goes to another state, then what happens? Nashia temple now has got the elephant. What Nashia temple would do? That section 43, subsection 2. Where a person transfers or transports from the state in which he resides to another state or acquires by transfer from outside the state any such animal, article, trophy or uncured trophy, in respect of which he has a certificate of ownership, he shall, within 30 days of transfer or transport, report the transfer or transport to the Chief Wildlife Warden or the authorized officer within whose jurisdiction the transfer or transport is effected, provided that the transfer or transport of a captive elephant for a religious or any other purpose by a person having a valid certificate of ownership shall be subject to such terms and conditions as may be prescribed by the central government. Central government, my lord, in connection with this, has not made any rule as such till date. So this is it. So, my lord, once the Nashia temple gets the elephant, it is the duty of Nashia temple to inform its Chief Wildlife Warden that a person having the certificate of ownership has given this elephant to us. Elephant had entered the jurisdiction of Tamil Nadu with the approval of the Chief Wildlife Warden. Chief Wildlife Warden now has the knowledge that Nashia temple has got the control and possession of the elephant within the scheme of section 43, subsection 2. So, my lord, submission that I have made is in my write-up. Lordship may see kindly paragraph 10 of my small note. That's the submission I'm making. Under section 43, subsection 2 of the Act, where a person acquires by transfer a captive animal from outside the state, which is covered by a certificate of ownership, then within 30 days of transfer of such animal, the report of the transfer or transport has to be made to the Chief Wildlife Warden or the authorized officer within whose jurisdiction the transfer or transport is effected. Hence, the scheme of the Act does not make captive animal the exclusive property of any particular state, and control over such captive animal can be shifted from jurisdiction of one state to another state. So, my lord, my submission is the jurisdiction over Joymala has been shifted from the state of Assam to the state of Tamil Nadu under the protection of the Chief Wildlife Warden of the state of Tamil Nadu. Since the state of Assam does not have any legal right over Joymala anymore at this stage, Therefore, the state of Tamil Nadu does not have any corresponding duty as such. Initially, they agreed, but subsequently, in the changed circumstances, they realized, no, they will stick to their stand. They will not send the elephant. Now, my lord, so far as the high-powered committee is concerned, I'm not talking about the dispute, my lord. Over here, when the matter came up before the Supreme Court, it was in connection with that there has to be a proper modality throughout the country in respect of the captive elephants, because captive elephants are in different states. So there has to be one nodal authority to look into the entire issue pertaining to captive elephants everywhere, regardless of the dispute or not. Initially, my lord, there was a judgment of the High Court of Tripura in Sudiptanath case, which was in respect of a particular state only. But Supreme Court in subsequent two judgments extended the scope of the judgment and gave it all India jurisdiction. The first case, my lord, on the subject is MS Murli case. This I will place first. MS Murli. Lordship may have a copy. In MS Murali, my lord will find para 7, 8, and 9. 7 I will skip. The background they have given in paragraph 7.
Yes, paragraph.
Now, my lord, paragraph 7 gives the background, so I will skip that. I will read para 8 and 9. 7 is the background, what happened and how the Tripura High Court passed the judgment. Now we are extending the scope of the judgment to all India that way. Paragraph 8. Para 8. Though the scope and jurisdiction of the high-powered committee was limited by the High Court to transfer of the elephants from northeast part of the country to the elephant camp of respondent 3, that is Bantara, my lord, actually. We see no reason not to extend it to pan-India, particularly when by extending the jurisdiction of high-powered committee at pan-India level will not only serve the real public interest and would advance the cause of welfare, care and rehabilitation of wild animals, but will also curb the filing of frivolous PILs before different high courts by busy bees. Then para 9. In view of the aforesaid facts and circumstances, we deem it appropriate to extend the jurisdiction and the scope of high-powered committee as constituted by the High Court of Tripura with the modification that the Chief Wildlife Warden of the state to which the issue relates will be the co-opted as members of the said committee in place of the Chief Wildlife Wardens of Tripura and Gujarat throughout the territory of India, leaving it open to the committee to conduct necessary checks and to undertake fact-finding exercise in any pending or future complaint in this regard. Thereafter, my lord, in a subsequent judgment in the Prerna Singh Bindra, the Supreme Court further extended the jurisdiction to other areas. This Prerna Singh Bindra, lordship may kindly have a copy. In Prerna Singh Bindra, my lord, para 2, para 3 onwards. Para 2. Internal page 8.
Page 8.
Internal page 8 of Prerna Singh Bindra, paragraph 2. Court refers to MS Murli case, the salient features and all that. Then, my lord, Para 5. The submission of the learned counsel itself, my lord, was incorporated by Supreme Court. Para 5, lordship will come. Such and such senior counsel submitted that the remit of the HPC should also cover the following aspects: duration of ownership certificate in relation to elephants, inquiring into the capacity of the facility where the elephants are proposed to be transferred, monitoring of the health and age of the elephants, monitoring the facilities for transportation, and the need to shift elephants. So even the need to shift elephant from one place to another will be within the domain of the high-powered committee. Para 7. The remit of the HPC would comprehensively cover all aspects, including those which are sought to be raised on behalf of the applicants as noted above. In other words, all relevant aspects are entrusted to the decision-making process of the HPC. So, my lord, even these suggestions were incorporated by the Supreme Court that even the need to shift the elephant will be looked into by the high-powered committee itself, because it's a captive elephant. So this is it. So, my lord, so far as now, my lord, I'll turn to now. So far as, my lord, the limitation is concerned, one of my submission would be that 17/9/2013 was the outer limit. 17/9/2013, the agreement was between the government of Assam and the Green Moran. The privity was between them. Not state of Tamil Nadu is not bound by what transpired between the state of Assam and the Green Moran. 17/9/2013, Green Moran could have acted, could have done something about it. For 8 long years, everyone slept. Government of Assam did nothing. Government of Assam did not take up the issue with the Green Moran also. Why don't you bring your elephant? Because Green Moran, it seems, my lord, did not disclose that he had already executed the gift deed. And the elephant was given to the Nashia temple for good. This, it seems so. That's my hypothesis. So, my lord, in 2021, in the list of dates, my lord will find, sorry, that copy I did not give it to my lord. It is, my lord, FIPAO 25/2/21. The first letter was there. It is annexure J, page 4650 of the writ petition. They have annexed it. It's an NGO. 25th of February 21 was the first spark, practically after 8 years. All along, elephants are there.
Page?
Page, my lord, 46 to 50 of the writ
No, no,
petition.
in this note of yours, on which one have you given this?
My lord, list of date. From the list of date,
Yeah, no,
the second page, internal, list of date.
this is the notes on submission.
Note of submission and the list of dates. Two things I have given to my lord.
No, these are the same. You have given the same copy. No, right. It will reset. This you have already given.
Two copies, possibly, my lord, there is some,
No,
the
no, this is
copy
the-
which I gave now, my lord, I think is a revised copy, so lordship may kindly have this.
No, it's just, you have just handed over this.
Maybe it was there earlier, some time ago. What is that?
Already given this notes on submission, you have already given, handed over.
My lord,
You
may
can hand
I,
it.
may I have a look at both the copies?
Yes. You can give a list of dates.
Oh, yes, yes, yes. But two copies were given instead of one. What happened? I give
One, I think, instead of, you have to hand over the list of dates.
list of dates. List of dates. So what did you give? Oh. Dates of date, internal page. 2. (25 to 21). This is the first spark. So far as the state of Assam is concerned, my lord, state of Assam acted for the first time on 8th of March 21, writing a letter to Tamil Nadu government. So, my lord, 8 years, everyone slept. So total and complete lack of due diligence on the part of the state of Assam. For such a long time, the elephants are there in Tamil Nadu.
Yes.
This ground Lordship will consider. Then comes, my lord, Article 131C for a moment, Lordship may kindly have a look.
Yes.
Article 131C. In my note on submission, I have taken this ground. (131). Subject to the provision of this constitution, the Supreme Court shall, to the exclusion of any other court, have original jurisdiction in any dispute. As to what is the dispute, I will explain, my lord. Between the government of India and one or more states, between the government of India and any state or states on one side, and one or more states on the other, or C, between two or more states. Then comes, my lord, the two lines which are very, very important.
Yes.
If and in so far as the dispute involves any question, whether of law or fact, on which the existence or extent of a legal right depends. My submission would be on this. The state of Assam is seeking the return of Joymala after 8-9 years. On the ground, it still enjoys jurisdiction and right over the Joymala, as if the Joymala is a property of the state of Assam and it has to be handed over to the state of Assam. The state of Tamil Nadu denies that part. That Joymala is not the exclusive property of the state of Assam. And on the contrary, it is the state of Tamil Nadu which exercises jurisdiction over it. So that is the legal right. Now, my lord, the legal right has been, these two lines, my lord, came for interpretation of the Supreme Court, a series of judgments. Two of the Constitution Bench judgment, my lords, are familiar, namely Rajasthan case followed by Karnataka case. In Karnataka, they said it's a generic, the legal right. Legal right can be of plaintiff only, or legal right can be of the respondent only. This is what in Karnataka Justice Baig says. Now, my lord, in Karnataka case, Supreme Court also made a distinction very clearly. The court said, because the argument was government and the state are two different things. Dispute can be between the two governments. Then, my lord, there is a beautiful observation of Chief Justice Baig in the Karnataka case that the government and the state, the difference between the two is one is the whole and the other is inseparable part of the whole. So government is the inseparable part of the whole, which is the state. They are one and the same thing. Even if the dispute is between the government, the state comes into play. It is the state which is controlled by the government. So, my lord, I'll just, my lord, the relevant observation, I will cite only one judgment. That is the submission I have made, my lord, in my written note, para 4 of my written note. The relevant paras I will give of Karnataka case also. I have cited only one judgment where Karnataka was referred. The observations of Chief Justice Bhagwati. The subject matter of the presented petition involves question of law or fact on the existence or extent of legal rights of the contesting estates on captive elephants, and as such, the dispute is covered by Article 131C of the Constitution of India and is within the exclusive jurisdiction of the Honorable Supreme Court. Now, my lord, 2004-12 SCC. 673, para 36.
Citation, please.
My lord, 2004, 12 SCC 673, paragraph 36.
Name.
I just read para 36 at page 692.
Haryana, Punjab case.
Yes, yes, because they have referred to the Constitution Bench judgment. They have quoted a relevant observation. The primary consideration in answering the first question is the legal right claimed by the plaintiff.
Let us have a copy first.
I'm sorry, I'm very sorry. I may give my lord my
No,
copy.
we can have a
lordship.
copy. He call he paste to dile hola. Page ulaisa nik. Only page to paragraph 30, first page and paragraph 36.
The emphasis of the honorable court is on the point, my lord, the issue must be legal, not political. So that is political thicket and judicial hands off. Issue here is not political. Of course, behind, my lord, politics is always there. We all know both the states are going for election. There's a different matter. But the legal issue has been raised now.
Yes.
The primary consideration in answering the first question is the legal right claimed by the plaintiff. Unless the plaintiff can establish that there is such a right in law, there would be no question of this court deciding any dispute regarding the extent or existence of such right under Article 131. As was said by Bhagwati J. in the state of Karnataka versus Union of India, para 201 they have quoted. Now plainly, there are two limitations in regard to the dispute which can be brought before the Supreme Court under Article 131. One is in regard to parties and the other is in regard to the subject matter. The other limitation as to subject matter flows from the words if and insofar as the dispute involves any question, whether of law or fact, on which the existence or extent of a legal right depends. These words clearly indicate that the dispute must be one affecting the existence or extent of a legal right and not a dispute on the political plane, not involving a legal aspect. It was put by Chandrachud J very aptly in his judgment in the state of Rajasthan versus Union of India when he said, mere wrangles between governments have no place under the scheme of that article. It is only when a legal, as distinguished from a mere political issue arises, touching upon the existence or extent of a legal right, then the article is attracted. Hence, the suit in the present case would obviously not be maintainable unless it complies with both these limitations. Now, my lord, so far as the legal right is concerned, the relevant observation of Justice Bhagwati, my lord, may also find in paragraph 204 in the Karnataka case. Paragraph 204, that is, my lord, (1977) 4 SCC, that is the Karnataka case, Constitution Bench. 1977 4 SCC, page 608. Legal right is generic. Para 204 at page 709 in the Karnataka case.
Please give the citation. 77 4 608.
608.
Sorry.
Relevant paragraph 204.
204 thaka paragraph 2 idea.
Court widened the scope of the legal right. Internal page 709. That is 7 just Constitution Bench. I read, my lord, page para 204. It may also be noted that on a proper construction of Article 131, it is not necessary that the plaintiff should have some legal right of its own to enforce before it can institute a suit under that article. it is not a sine qua non of the applicability of Article 131 that there should be infringement of some legal right of the plaintiff. What Article 131 requires is that the dispute must be one which involves the question on which the existence or extent of legal right depends, quote unquote. The article doesn't say that the legal right must be of the plaintiff. It may be of the plaintiff or of the defendant. What is necessary is that the existence or extent of the legal right must be in issue in the dispute between the parties. Then, my lord, it has been very elaborately discussed in subsequent two paragraphs, paragraph 205 and paragraph 206. So far as, my lord, government and the state are concerned, one is the whole, other one is the inseparable part of the whole. My lord will find this observation in paragraph 144 of Chief Justice Baig at page 685 in the Karnataka case. I'm just giving the reference, my lord. Page 685, paragraph 144, the majority view, my lord, Chief Justice Baig. So, my lord, my submission is either, my lord, the matter may be referred to the High Powered Committee because it falls within the terms of reference, because there would be requirement of shifting the elephant from Tamil Nadu to Assam. And otherwise, my lord, the government of Assam must have a legal right over the Joymala so as to seek mandamus from this honorable court, without which the state of Tamil Nadu has no corresponding legal duty towards the state of Assam. And Lordship may consider rest of my submissions, my lord. I have given that in a note. And
Yes.
That is it.
Yes.
Obliged, my lord. That's all, my lord. Since my note is there, I need
Yes.
not elaborate further.
Yes, would you like to appear? Somebody is online?
Millet, sir.
It seems
Millet, I am
Darshan temple.
appearing for the, Millet, I am appearing with the temple. If your lordship will permit me to appear online, Millet.
Yes.
Yes.
Can we have your submission?
Millet, may I indicate what my submissions are, Millet? Millet, first is Millet.
Just a minute, we'll have to increase the audio. Can we get your name?
Arpudam. ARPUTHAM.
Okay. Yes, please. What is it?
May I briefly indicate what my submission is, Millet?
Yes, please do.
Millet, if your lordship will look at the prayer and the writ petition, what is prayed, what is asserted in the writ petition?
You are for the respond number?
Respondent number 11, where the elephant in question is.
11 has been newly implemented.
It was implemented later.
Subsequently implemented. Yes.
Well, the prayer and the writ petition is for a mandamus directing the state authority, state of Tamil Nadu, to cooperate and facilitate the return of the elephant to the state of Assam.
Correct.
This is founded on an assertion in the writ petition that the Chief Conservator of Forest and all the state of Assam has a fundamental right in this regard. Except saying that they have a fundamental right, which fundamental right they have is not asserted or identified. Property was a fundamental right earlier, not at the time when they filed a writ petition. Number two, whether a functionary of the state government has a fundamental right as against another state government. My submission is, Millet, it is not there. First submission as far as that is concerned, Millet. Second, I will elaborate all this, Millet. The second submission is, Millet, there is no territorial jurisdiction for them to seek this relief from your lordships. The elephant is in the state of Tamil Nadu, admittedly, since 2011. Cause of action arose within the state of Tamil Nadu. The cause of action is refusal by the state of Tamil Nadu, refusal by the temple to return the elephant. That earlier the state of Assam permitted the transport of elephant is not a cause of action. It's one of the details of the facts how it happened. What triggered the cause of action? What is the thing that they are complaining about is that state of Tamil Nadu and the temple is not returning the possession of the elephant to the state of Assam. So therefore, no part of the cause of action has arisen within the state of Assam for them to approach your lordships for that relief. If at all, they could have gone to the state of Tamil Nadu, filed maybe a writ petition in the High Court or a suit. That's the second submission. Third submission is, Millet, as at present, Millet, there is a specific order of the division bench of the Honorable High Court, wherein a complaint was made. The state is proposing to return the possession of the elephant to the state of Assam. An order is passed by a division bench of the Honorable High Court saying that it will not be returned. In the sense, an undertaking is given by the state to the division bench of the Honorable High Court. It will not be returned to the state of Assam, but it will be taken care of in the state of Tamil Nadu.
Now, but let us see that undertaking.
Yes, Miller.
The order does not reflect. Kindly kindly lead us to the order of the
Yes, Miller. Would you like
division
to
bench.
would you like to the page 224 minutes?
Yes, 224, please. Yes. Yes,
You like to got that minutes?
yes,
The order is dated 15/9/2022.
yes,
That your lordship will get on the top minutes.
correct.
Is the division bench of the Honorable Chief Justice and another Honorable Judge of the High Court minutes. Your lordship will see what are the parties minutes, functionaries of the state government or the parties. State of Assam is not a party. I will come to that in a minute. And minutes, which are the elephants which are concerned minutes, if your lordship will come to page 225. On the top, item 7 is Joymala, the elephant in question. There were nine elephants involved, which have come from the state of Assam to the state of Tamil Nadu. Now, Milas, if your lordship will come to the order. The petitioners has filed the above writ petition as a public interest litigation seeking issuance of a writ of mandamus, directing the respondents to continue to retain the 9 elephants mentioned in the petition in their respective temples permanently.
Yes.
For the care and maintenance, and to consequently direct the respondents to take all measures in accordance with law for more upkeep in the welfare and maintenance of the temple elephants in the state of Tamil Nadu. This is a relief asked for. In the case of the petitioner, that a video clipping was circulated alleging harassment caused to the elephant in one of the temples in the state of Tamil Nadu, and hence the government of Assam is taking steps to take back the temple elephants gifted by the individuals in Assam. Issue. When the writ petition is taken up for hearing, so-and-so learned additional advocate general appearing on behalf of the respondents on instruction submitted that the respondents have no intention to send back the temple elephant to Assam and they are taking care of the temple elephants in the best possible manner. Then, Millet, in view of the submission made by the learned advocate general, to the effect that the respondents are not going to send back the temple elephants to Assam, and that the respondents would take care of the temple elephants in the best possible manner, we do not find reason to give any further directions to the respondents to take care of the temple elephants. Therefore, the petition was filed saying alleging that the state of Tamil Nadu is proposing to send these elephants back to Tamil Nadu. It should not be done. The state of Tamil Nadu should take care of it in state of Tamil Nadu. State of Assam is not a party to this petition. They are perfectly entitled to say we were not aware of it. But this judgment of the Honorable Division Bench of the High Court was placed before your lordships in the present proceedings by way of an affidavit on 5/8/2024. The date of the affidavit your lordship will get at page 223. Date of the affidavit. 5/8/5th August 2024. Your lordship have got that, Milas? Page 223.
Yes.
5/8 oath Milas. 5/8 this thing, it is file Milas, is a part of the affidavit. And averments in this regard are contained in page 209, para 6. So my submission in this regard is Milas, from 5th August 2024, the state of Assam is aware of a division bench judgment of the Madras High Court, the effect of which is the functionaries of the state of Tamil Nadu are bound not to return the possession of the elephant to the state of Assam.
Yes.
Even if they were not parties to the thing, they were not parties. If at all they were aggrieved by this,
they should have challenged this order before the Honorable Supreme Court by way of a special leave petition saying that this order is incorrect, not valid for whatever reason is concerned. Till today, it has not been done. The difficulty arises in this manner, Millets. Today, there is a mandamus. In effect, there is a mandamus by a division bench of the Madras High Court, which is binding on the functionaries of the state government that they shall not return. An undertaking by them, recorded by the court, disposed of in that. In substance is that you will not return it. Contrary to that,
But, Mr. Senior Counsel, is there a mandamus? Is this a mandamus?
all right, Millet, let us say there is an undertaking binding on the state government, Millets.
That undertaking is the subject matter of challenge, whether that undertaking can be a valid undertaking.
Yes, Millet, that has been challenged. As long
That
as
is what we are trying to adjudicate. But do you actually think that this DB order would come into the way of adjudication?
Yes,
You may have,
this way, Millet,
you
this
may
way,
have a
Millet.
valid argument raising the aspect of territorial jurisdiction. That will answer.
Millet, I will come to that.
That will definitely answer. But
Millet,
this
I am at the preliminary stages indicating, Millet.
Yes,
Now,
yes.
Millet, what they want is, the petitioners in the writ petition want is an order from your lordship that the state of Tamil Nadu shall send the elephant back to the state of Assam.
Yes.
Let us assume, Millet, your lordship pass such an order. It will in effect mean that the functionaries of the state of Tamil Nadu who are given an undertaking to the Honorable Division Bench of the High Court, which is binding on them, have to violate that particular order. Would your lordship in an ordinary circumstances give such a mandamus to the functionaries of the state of Tamil Nadu to violate an undertaking? Forget the mandamus part of it. To violate a solemn undertaking, they gave it to the High Court and then return the possession of the elephant to the state of Assam. When the state of Assam, after becoming aware of it, till today have not challenged it. Therefore, Millets, in view of the binding judgment of the Division Bench of the Honorable High Court, your lordship will not give such a direction is my submission, Millets. Then, Millets,
Yes.
in the petition, it is alleged that the state of Assam has a fundamental right. But the state of Assam has a fundamental right as against anyone, it does not have. Does any functionary of the state of Assam has a fundamental right to assert as against the sovereign executive rights of the state of Tamil Nadu? No, they don't have. Forgetting that what they pleaded, etc., etc. In substance, today it is admitted that the state of Assam has no right over the elephant. State of Assam is not the owner of the elephant. Whereas initially and in the subsequent pleadings also, rejoinder also, state of Assam asserted that it is the owner of the elephant and they are entitled to seek this mandamus. Who was the owner of the elephant, Millets? It is one Moran, what is his name? Girin Moran, who admittedly was the owner of the elephant and who had a certificate of ownership in his favor. As a owner of the elephant, Millets, he is entitled to deal with the property. It is individual property, he has his rights. He could have gifted it to somebody, his neighbor in Assam. State of Assam cannot complain. Equally, Millets, he could gift it to a temple in Tamil Nadu. There is no bar in law. What is prohibited under the Wildlife Protection Act is only sale for consideration. It is not a sale for consideration. He executed a gift deed. They are aware of the gift deed. After the execution of the seal deed,
Can we have a look at the gift deed?
Yes, Millets. Would you like to come to the gift deed straight away, Millets?
Page 254.
Page 250.
Who were the signatories in the gift deed?
Your lordship will give me a minute.
Page 254.
Page 50.
Executive officer of the temple and Green.
Would you like to the page
254.
Millets?
This is
The
not a
second
registered
one-
document. Number one, this is not a registered document.
Millets,
Number two, a more important question. Where is the acceptance of the gift?
Second page, Millets.
Where is the acceptance?
Your lordship will give me a minute. If your lordship will come to page 255, Millets.
Yes.
I further declare that the SIP has been made by me out of my natural love and desire, and the same has been accepted by the donee.
Where is the acceptance? Is there any signature of the donee?
This is the bottom, executive officer. Well, there's a, I'm not sure, I don't want to make a submission in that regard, whether it is actually one showing acceptance or only or it is certifying this particular document. Let me for the time being leave it, Millet, that as far the ownership is concerned.
Yes.
That
But this,
whether it's a
perhaps would not serve the purpose. Because there is no acceptance.
Very well, Millet. Let me for the time being at this stage
Yes.
proceed on the footing that
Yes.
as far as the gift deed is concerned, this may not have the effect of transferring ownership of the elephant in
Yes.
favor of the temple, whom I
Correct.
represent, Millets. But that does not in any way, Millets, there is nothing by which the state of Assam acquires title to the elephant. At the most, it will mean that Mr. Green Moran continues to be the owner of the elephant,
Yes.
not I, the temple. But Mr. Green Moran is not the petitioner saying that please return the elephant to me and seeking your lordship's assistance in this regard. He has not come before your lordship to say, I gave possession of this elephant to the temple. That is not disputed. State of Assam only facilitated by permitting it to the transfer as far as that is concerned. Possession of the elephant is given by the owner to the temple. That owner who gave the possession of the elephant to the temple has not come before your lordship complaining that the temple has not returned the elephant to me. Next, let me say, take it that state of Assam says it was to be there in the temple for 3 years. Very good. So, not 3 years, 2 years, something up to September 2013.
Yes,
So,
17 September 2013.
2013.
Yes.
Within what time the owner or anyone else on his behalf could seek return of the possession of the temple? Under the Limitation Act, the period is maximum period is 3 years for recovery of a possession. Now, the temple and the state of Tamil Nadu have not returned it. The cause of action as far as that grievance arises in the year 2016. 2013 it arises. Immediately after that period is over. The next day, 18th September 2013, the cause of action arises because at the end of the 3-year period, the possession of the temple is not returned by the temple to whom possession was handed over. What is the period of limitation for recovery of the possession of the temple? If a suit is to be filed, it will be 3 years. That expired in the year 2016. 2016, nothing is done. 17, 18, whatever is concerned, nothing. And as far the owner is concerned, till today it has not been done. Now, what is the effect of not filing a suit within the period of limitation, seeking possession of the movable property? Elephant is a movable property. There are judgments. There is no problem. It's a movable property. Not seeking return of the possession, which has been denied. They have not returned it. If your lordship will come to section 27 of the Limitation Act.
But as you know, this is a writ proceeding. This is not a suit.
If
We are not bound by the strict rules of 1960.
If your lordship will just be patient with me for 2 minutes.
Yes, yes.
The right is lost. The right is lost.
I'm just indicating that 63 Act per se is not applicable, but the aspect of laches will definitely be applicable.
That's one part of it. My submission is little more than that, Miller.
Yes.
On the date the writ petition was filed, did anyone have the right? Did Green Moran have the right to the elephant? No, he had lost it by virtue of section 27 of the Limitation Act. Would you lordship have a look at section 27 of the Limitation Act? I have extracted it. Where is that page? 210?
Oh, we'll have it.
Yes.
27.
Page 4 of my document.
Your Lordship will just bring in.
Yes, section 2, extinguishment of right to property. Is it that you're trying to
Yes,
indicate?
yes, Millet. Section 27. At the determination of the period hereby limited to any person for instituting a suit for possession of the property, his right to such property shall be extinguished.
Yes.
It is a very special provision, Millet. Ordinarily, the right to sue is lost. The right is not lost. Section 27 is a very special provision in regard to property, movable, immovable, etc. If he had not taken steps within the period of 3 years, he should have done within 3 years. I am not on the question writ petition, suit, etc. The right is lost. He is no longer the owner of the elephant. So in 2022, a writ petition is filed before your lordships asserting a right of ownership, either by Green Moran or somebody else, over the elephant. There is no such right in existence. In the absence of a right in existence, how can they file any proceedings, be it writ petition, application, suit? That I am the owner of the elephant, please return it. You have to establish your right. That right stood extinguished in 2016 by virtue of operation of section 27 of the Limitation Act. So, as on today, in 2022, when a writ petition is filed by a person who is not an owner, asserting a right over the elephant which it does not have, which the learned advocate general has now accepted that state of Assam does not have ownership over the elephant. This writ petition is not maintainable and in any case cannot be allowed. Also for the reason that there is a judgment of the division bench of the Honorable High Court recording an undertaking that the officials of the state would not return the elephant to the state of Assam, and they are asking for a writ of mandamus for your lordships against them that it should not be, that they should violate the order. Then in regard to Article 131.
Yes.
This suit, if your lordship will look at the cost item, is by the state of Assam. There are two aspects in that regard. I will come to that one by one. Is by the state of Assam, represented by the principal chief conservator of forest. Then the principal chief conservator of forest himself is a party. Then chief wildlife warden is a party. And again the Union of India and other functionaries of the state government. So what is asserted, as I mentioned to your lordship, page, if your lordship will come to page 4 or 5. Page 5, very first paragraph,
Yes.
that the principal chief conservator of forest as a fundamental right under part 3. And he has come before your lordships asserting that. Your lordships have got that,
Page 5, yes.
Principal chief conservator of forest, chief wildlife warden, etc. They have rights guaranteed to them under part 3 of the Constitution of India, and they have come to assert that right.
Yes.
First is, if an right is asserted in the state of Assam against the state of Tamil Nadu, with the state of Tamil Nadu disputes, the remedy would be Article 131 of the Constitution of India. Because two sovereign states, sovereign in the sense not as a nation in that sense, constitutional entities, states, one claiming a right and another denying that right. If that be so, the forum which is competent to adjudicate that dispute to the exclusion of all other forums, Article 131 by the learned advocate general placed before your lordships, is the Supreme Court of India. Apart from the fact that, the suit, this writ petition, purported to be filed by the state of Assam, by the principal chief conservator of forest, is not maintained. the principal chief conservator of forest is not a person who is competent to represent the state of Assam. I can understand if the writ petition was filed by the chief secretary of the state or secretary in the Department of Environment and Forest. No. He is a mere functionary. He is not even a juristic person. I will show it to you, Lordship, the judgments. And he is not competent to file a petition on behalf of the state of Assam. I squarely raised it in one of my affidavits. In answer to that, what is pleaded is he is competent. And he says he is placing on record a document in that regard. But what he actually places is his promotion order to that particular post. That is promoted to a particular post, not an answer. Has the state of Assam authorized the principal chief conservator of forest to file this petition? No. Till today, nothing has been placed on record, even after raised an issue that he is not competent to do so. Would you like,
Yes, yes, we may agree on with you on this. State cannot be represented by the principal. We may not have any dispute, but the
not
answer.
maintainable because not in there is such a in the state of Assam.
But
they are
there is
not
another
properly
issue.
asserted.
Another issue. There are two more petitioners.
Let's-
Who is the PCCF himself and the chief wildlife warden? Whether a petition
None of them,
can be
none of them have
maintained
any
by
right.
them.
No, none of them can maintain a state on behalf of the state of Assam.
No, you are correct.
State
You
of
may
Assam
be
is the
correct.
constitution.
You may be correct. The state cannot be represented by the PCCF. We may not have any dispute. I think it's not a correct description. It cannot be done. But there are two other independent petitioners, namely the PCCF
Yes, Millet.
and the chief wildlife warden.
They also cannot, Millet. They have no fundamental rights which they assert. What is the fundamental right they have to assert against the state of Tamil Nadu? What is the rights they have against the state of Tamil Nadu? None. If at all there are any rights, it is the right is in the state of Assam. Assuming against me, there is some right against the state of Assam. It is the state of Assam which will have a right, not a functionary. They assert they have a fundamental right. What is that fundamental right? Fundamental right is by a citizen against the state, not by an officer against somebody else. So they will have to demonstrate to your lordships, except making a bold averment, that I am here to assert a fundamental right. And this fundamental right is asserted against what, Millets? A movable property, an elephant. There is a problem with the grammar, Millets. In the past, it would have been all right. Property was a fundamental right. 19(1)(f). Not after 1978. In the present day grammar, when they are asserting, I have a fundamental right, it is not there. If it was filed before 1978, maybe I may not be able to argue this thing. So therefore, Miller, they don't have any rights, fundamental or otherwise. And even assuming if they had a right to return of the elephant, it is lost in view of Section 27 of the Limitation Act. And what is that they came before your lordships with? That there is an allegation the elephant is not being treated well. Your lordships repeatedly asked for various reports. They are submitted even now. It is not their case that the elephant today is being ill-treated. Let me assume that the elephant at one particular point of time had been ill-treated by a person who was entrusted to care for it. Action was taken against him. He was dismissed from service. And if that be so, the remedy is under the Prevention of Cruelty to the Animals. One has to file a complaint before the jurisdictional magistrate alleging cruelty to that particular animal. He is competent to look into the matter, including send the person to jail for a period of 3 months, etc. Not done. Not a writ petition, allegation, because when statutory remedies are provided in terms of all these Millets, it has to be followed. And today that complaint is no longer persisting. It is not their case that today the elephant is, and Millets in South, there is a little more problem as far as that is concerned. It's not a legal argument, Millets. Elephant assumes the status of a deity. It is worshipped as a temple. I'm not on the sanctity of it, whether right legally in law is right or anything. People after marriage go to the temple. The bride and bridegroom, they take the blessings of the temple. When a child is born and it is taken out, it is first thing they take it out to the temple to take the blessings of the elephant. Today, Miller, this elephant is almost like a deity in the temple, being worshipped by the people, being looked after by the people and the temple there. These are also relevant factors in the context of. Therefore, Miller, these are my broad submissions. Now, if you choose one, Miller, I will go into the details of it, show each one of them, and make my submissions further.
I think you have been elaborate enough. We have had your submissions recorded. If you want to stand on some points, you can do, but you have covered everything.
May I just give the reference to a few judgments, Miller? My learned colleague there, Miller, there's a compilation of judgments which I have given to.
Yes,
I will only
please.
hand it up, your lordship may see in the light of my submissions.
Yes,
And
yes.
there's one judgment in that also to the effect that the chief conservator of forest is not competent to maintain proceedings on behalf of the state, and that he is not even a juristic person.
Okay.
So, Millers, in the light of these broad submissions, Millers, my humble request to your lordship is that, Millers, this writ petition deserves to be dismissed.
Can you indicate on your citations?
May.
We can just make a note.
Yeah, your lordship will just give me a minute. Just give me a minute. Millers, page 1. Is a 9-judge bench of the Constitutional Bench of the Supreme Court of India.
Yes.
To the effect that an artificial person, in the sense juristic person, it was a company,
Right. Yes.
has no fundamental rights under Article 13. Miller, this is in the context of a right asserted to property, even though it is not there. I take it that they claim some right in respect of that. But a juristic person has no fundamental right as far as the right to property in the elephant. It may not be a much because now they are not claiming any right of ownership in respect of that. Then you come to the later judgment. Page 73, telco is to the same effect. That also your lordship can skip. Then Millers, thereafter Millers, if your lordship will come to page 88. Page 88 is a judgment of the
Punjab and Haryana.
Punjab and Haryana High Court. This is for the limited purpose that elephant is movable property. This is for the purpose of my submissions under section 27 of the Limitation Act. Right to property is lost. Elephant is movable property. It is for that purpose, Millers. If you lordship will have paragraph 4 at page 90. And also para 8 at page 92. Then Millers, page 95 is to the same effect of the Andhra Pradesh High Court.
Regarding?
That it is animal is a movable property.
Property. Then
The next judgment in this compilation is Millers at page 98. This is not a judgment I have been relying upon. This was a judgment earlier relied upon at the initial stage of the hearing of this case to say the writ petition is maintainable. The submission in this regard is Millers, this judgment does not support that position as for the maintainability of that thing. On the other hand, if you lordship will look at para 12, this was a dispute about what is it? Commercial sanctions. Dispute about tax. State claimed that no. This is a dispute where some railways lost some properties in respect of there are some proceedings, etc. If your lordship will come to para 12, what is covered by article 131 is when a dispute first two lines, when a dispute arises between among the states of the Union of India in the context of the constitutional relationship that exists between them and the powers, rights, duties, etc. Here it is squarely that they assert a right that as a constituent entity of the Union of India, they have a right as against me, which I dispute. Therefore, it will be 131. So this judgment does not support their position that it is. Then the judgment at page 107.
ONGC.
107.
ONGC.
ONGC.
What is the
Cause of action arises in state of Assam litigate jurisdiction.
This is
ratio?
one relating to cause of action. Nothing much on that. I will take it to your lordship to a later judgment. Then, if your lordship will have page 120. National Textile Corporation.
Mhm.
This is also relating to cause of action, Millets, as to where somebody filed a writ petition in the Calcutta High Court in regard to a dispute which was in Assam, money in Bombay. Goods were purchased in Bombay, payments were to be made in Bombay. They did not. They filed a petition in the Calcutta High Court. The court held that it is Bombay and not Calcutta which is the jurisdiction, and the relevant paragraphs should be paragraph 12 and 12. 12.1 in particular, Millets. Then Millets, page 135. In this judgment, Millets, the relevant paragraph is para 11 at page 139.
What is the ratio?
The importance in this, Millets, paragraph 11, that section 27 of the Limitation Act is a very different from ordinarily what is. When the right to sue is lost, may I just read it in Millets. Limitation is a statute of repose. It ordinarily bars remedy, but does not extinguish the right. That is at page 139, Millets, para 11. It only exception to the said rule is to be found in section 27 of the Limitation Act, which provides that at the determination of the period of prescribed thereby, limited by any period so and so, the right to such property shall be extinguished. So it deals with section 27 and affirms what is contained in section 27, that the right itself is lost. Then, Miller, the next judgment is page 144. In that, Miller, straight away I will take your lordship to para 30, which is at page 151. That in a petition under Article 226, what are the things to be looked at? Miller, if a suit is filed, Miller, section 3 of the Limitation Act says, even if the defendant has not taken the plea of limitation, the court shall look into the question whether the suit is within limitation, and if it is within limitation, even if the plea is not taken, it is liable to be dismissed. Now, in a 226 jurisdiction, I understand, Miller, that Limitation Act in the stricto sensu, it is not one. Then, Miller, what is mentioned here is, Miller, if your lordship will see, the person invoking the jurisdiction is guilty of unexplained delay and laches, as in the present case. From almost 10, 12 years, etc. Next is, Miller, expressly barred by law of limitation. So that's one aspect that your lordship will have to look into. And in this case, it is barred by law of limitation. And by virtue of section 27, the right itself had been lost. Then, Miller, then page 153, Miller, para 58. This is also on the point of section 27. Page 200, Miller. Okay. Para 58 minutes. Again, Miller, section 27 is dealt with and affirmed of the Limitation Act. Insofar as section 27 is concerned, Miller. Then page Page 203, State of Goa and Sumit Anle, paragraph, that's on the question of cause of action minutes. Essentially, what was challenged was acts of State of Goa, etc., etc. One of the things that was also challenged was in regard to certain proceedings in state of Sikkim. The court said, no, you have to look at the broad. And since nothing substantial had taken place, it will be without jurisdiction in. Then Millers, this judgment is important, Millers. The one at page 211, Chief Conservator of Forest, Government of Andhra Pradesh, 2003, 3 SCC 470. And the relevant portion is, Millers. In this case, Millers, there is a dispute as whether the land is patta land or government land. Adjudication by the Commissioner Land and Survey was that it is a patta land. The Chief Conservator of Forest claimed it is forest land. So proceedings were initiated by him. And in that regard, Millers, what the Honorable Supreme Court has to say as far as that is concerned, Millers, if your lordship will come to paragraph 6, the submissions.
Page 218.
Page 218. Para 6, the preliminary objection was raised that he is not competent to maintain the petition. Article 300. Then Millers, section 79, 80 CPC, and also order 1, order 27, rule 1. And one submission was also raised saying that Millers, between letters E and F, that the Chief Conservator of Forest is not a juristic person. Then Millers, it sets out the provisions, etc. And para 13. Para 13 at page 220. The question that needs to be, your lordship got that, Millers, page 220.
Yes.
The question that needs to be addressed is whether the Chief Conservator of Forest, the appellant petitioner herein the writ petition appeal so and so, misdescription of the state of Assam, or whether it is not a so and so. Then Millers, between letters D and E, every post in the hierarchy of the post in the government setup, from the lowest to the highest, is not recognized as a juristic person. Chief Conservator of Forest, even the other two persons, are not juristic persons competent to maintain a proceeding, and in any case, they cannot seek to represent the state of Assam. Then Millers, para 16, between letters F and G, the Chief Conservator, between letter F and G, Millers, at page 221, the Chief Conservator of Forest as the petitioner can neither be treated as the state of Andhra Pradesh, nor can it be a misdescription. So he was not competent to represent the state of. So here, Millers, the Chief Conservator of Forest claims that he. Then Millers, the next judgment is at page 225, which affirms the earlier judgment and said the collector was not competent. When proceedings were initiated by the collector, it was held that he is not competent.
Paragraph?
Paragraph, Millers. You'll have to give me a minute. Paragraph 15, Millers.
15.
15. At page 229. Last part of that paragraph, Millers, after referring to the earlier judgment which I showed you earlier, no individual officer of the government under the scheme of the Constitution nor under CPC can file a suit nor initiate any proceedings in the name and post he is holding, which is not a juristic person. So in this case, he was not competent. I raised this issue. In the rejoinder to that, Millers, may I just give you, your lordship, the page of my, where I have raised these issues and the answer to that, if your lordships want.
Yes.
Yes. Would your lordship have page? Would your lordship have page 403 of the paper book? I have just briefly set out what I have argued now, Millers. Page 404. That 131 is the remedy, not 226. There is no fundamental right in any of them. Then 4, Millers. assuming, next page, page 405, assuming without admitting the writ petition, the state of maintainable agency, it has not been instituted by a proper party. Saying that the chief conservator of forest, principal chief conservator of forest is not the competent person to do that thing. Then, I have dealt with other issues, limitation, section 27, extinguishment. No cause of action has arisen within the state of Assam. And by virtue of the gift deeds, the temple has become the owner. Now, in answer to that, village, only specific to this limited thing, village, saying that he is competent to.
That para where you say that he is competent, so that is para 6.
In para 6 at page 412, is it not?
Yes, 412.
412, toward the bottom, 412, he refers to the Wildlife Protection Act. There is nothing in the Wildlife Protection Act which empowers him to represent the state of Assam in a proceedings and institute any proceedings as far as the state on behalf of the state of Assam. He refers to at the bottom of minutes that executive business rules of 1968, but has not produced that or shown how he is competent to do that. But on the other hand, he says he is producing a document which is at page 413, which empowers him. You know what you will see at page 413, that saying that he is competent to do that. Now, if your lordship will go straight to page 417, what is the document which according to him empowers him to file this writ petition on behalf of the state of Assam? Page, what is the page? 417. 417 minutes. It is a promotion order. That is promoted to a particular post is not the same as he is competent. Maybe I can understand the state authorizes A, B, C by a specific authorization or general authorization to file the thing. Then they must, when I raise an issue, they must produce it. What he produces is, I was promoted to this particular position. That doesn't give you the right to represent the state of Assam. Well, these are broadly my submission. I'm extremely grateful to your lordship for the patient hearing, Millets. Is there anything else, Millets, your lordship want me to answer? Or?
Yes. Who's it? Who is it?
And the one lordship who has highlighted the issue way back from 2021 year old. And some vital facts in case people is
Who's are it?
lordship, it's an organization lordship. And it included lordship, right? Organization 17 then 2022 is the repetition.
Just a minute, please. Mr. Nayak, you'll have to meet the arguments advanced by the learned senior.
Other part I am doing,
But,
Lordship. So far as the judgments are concerned, Lordship, I would
No,
like
no,
to-
as regards the competence of the person instituting the writ petition,
Yes, Lordship.
state is not there.
State
How-
is not there, but under the law, Lordship, who is the authority to give the certificate for transporting and
No, to maintain a writ petition. Who's the legal entity? He's raised a
State.
very pertinent issue. We might have to answer this. Normally, these are not raised, but these are very, very important issues. We have diluted the system to
Lordship,
such an
I
extent.
tried to reply that, Lordship, in my affidavit.
This
subsequent-
promotional order will not give him the power to represent the state. State has to be by the chief secretary or secretary of the department. The PCC of a director doesn't become the state.
Lordship, on
These
that.
are all settled law. There is no scope of any further arguments.
Yes, Lordship, on
And
that.
these have been raised, so we have to answer it. We might have to answer it against you also. We do not know.
Lordship, my colleague has placed several judgments, Lordship. I would definitely like to.
Oh,
go
no,
through
no,
the
we'll
judgment,
give you a scope.
Lordship.
We are just indicating on what issue you need to address us.
Lordship.
As structuring of this writ petition was not done in the manner prescribed. How can the state be represented by a PCCF?
That point, Lordship, I'd like to definitely
And
give my.
the secretary is not, the second part is not the secretary of the department. Second is the PCCF. Third is somebody else.
Lordship, that point I reply.
Because in aspect of jurisdictional, the juristic person who has to be before us in for maintaining a writ petition, that has to be answered. It's been raised. If it was not raised, perhaps you would have not answered. Okay, Mr. Okay, we'll come back.
Lordship,
Mr.
not on today then.
Respondent number 8. Milord, we are an NGO, Milord.
Hmm.
We are looking after the welfare of wildlife stuff.
Okay.
Now it was.
You can come here. You can
Yes.
come. Or we'll have it at 2 o'clock, Mr. Chaudhary?
2 o'clock, another matter has been fixed at court number 1, Milord.
We cannot help, but now time.
2:30, 3 o'clock.
No, other side is, Mr. Mahanta, you're separately for the somebody.
Sir, our perspective is very limited.
Hmm.
Supreme Court has constituted a high power committee. Our cases, my lord, matters should be referred to the high power committee. Because the life of the, my lord, that animal is in danger.
But
They're
what
not
is it?
getting the proper care and treatment.
Now, are you opposing the writ petition?
Look, actually, we have intervened. We want the welfare of that, my lord.
No, that is okay. That is of paramount importance.
Yes.
But the writ
and
is.
our perspective is, no, my lord, either they should bring it back,
Yes.
which they have not taken any, other than filing this writ petition, state has not done anything. Now, when we.
No, when they had failed to get the cooperation of the Tamil Nadu government, therefore they have come to the writ court. Objection has been
No,
all.
in the interregnum,
Hmm.
our prayer is the HPC should take over the Milord welfare. In the interregnum.
No, there is an order brought on record of the Honorable Division Bench of the Madras High Court, wherein an undertaking was given by the Advocate General that the elephant has been properly taken care of, and as on today, there is no dispute to that fact regarding the welfare of the elephant. And rather than the welfare, we are adjudicating on the aspect of transporting it back.
Yes. No, that is the ultimate solution, my lord. If it is brought back and the owner should take it over.
We'll come back after.
Lordship, may I submit, Lordship?
No, we'll come back at 2 o'clock.
It's a vagile.
2 o'clock. Oh. Okay, at 2 o'clock, perhaps there may be some delay, there is some meeting, but maybe maximum by 2:15 we'll sit. Okay. Exactly at 2, it may not be possible. We're just indicating.
Your Honor, item 7, looking for short accommodation, may not be possible to take up today and adjourn.
Not now, no, come when the matter reaches.
Oblige.
As the first hearing after completion of the. Okay, then difficult. No, it was mentioned, we said that we'll give priority to your matter, but as the first hearing, but admissions, we are stuck in admission. 24. Yes, 6. Okay, and on 24th. Item number? Oh, paucity of time, 24th. Okay. Okay. Hopefully admissions will be less that day. Okay. Oh, yes. Today, this was some counsel from outstation council also there. Okay, yes.
I'll just take 15 seconds. Only one point I'm satisfied. I propose to introduce the definition of captive animal or elephant. It is there in definition clause, section 2, subsection 5. This I propose.
Section of the Wildlife Act.
Captive animal. The definition is definite value of wild animal, which is section 2, subsection 36. This is section 2, subsection 5. Defined separately, which is bred in captivity. Why don't we find the word?
2(5).
Animal which is bred in captivity.
And, okay. What is 236?
Because there is a clear distinction by this paper between the two. That's one part. And second thing, my lord, just very slight clarification. On our undertaking, since what I am heading with the state, I'll clarify that. Lordship may kindly take note of the fact that by that very particular judicial order, the PIL was disposed of. That order is an order of disposal. Therefore, it is a judicial order. And that order is based on the very undertaking itself. Undertaking culminated in the judicial order disposing of the PI. Therefore, undertaking is an integral part of the judicial order. And secondly, my lord, if the state of Tamil Nadu is made to deviate from that very undertaking, first of all, undertaking is before the honorable court. And secondly, by that undertaking, a right is vested in certain private parties. That is the basis. So they would be prejudice. Only that. That's all.
Private parties means?
Those petitioners in the trial.
Petitioners is represented today, they are at a temple.
That's the, but there were 9, nine of them.
We have heard them.
Including Joymala. There were 9 elephants. The PIL was filed on behalf of 9 elephants. Different authorities.
Okay, yes. Okay, okay. Yes, Mr. Chaudhary, where is? You're for R8. Where are you implemented? Who are you? PTA. Yes, yes, please. Your colleague is here, I think. But don't go to Arunachal now. This is not the time. You may go there and attend the court proceeding. That was not intended to make you sit. You can go. You can still go to Arunachal. Yes.
Later of 5th of March 2018, there are similar several letters. Where we have taken about the section 15 and subsection 1 is of wildlife protection act.
IA was for implement. That has been disposed of.
Yes, it is allowed. And just what is the purpose of the fund that that's managing the inputs made community
They are saying, but that archive we are not able to hear like that.
So similar representation of 13th of March 2021. First of June 2021. Different properties.
Yes.
Section 43 of the Wildlife Protection Act.
Hmm.
That go to section 8A.
Definition. Yes, definition. 48A. Okay. Or restriction.
Wild animal, other than vermin, or any.
What is a vermin?
Insects, but also like they are harmful. They are not the scheduled animals of state. Elephant is mentioned in schedule 1 of this one.
Restriction on transportation of wildlife. No person shall
Except any wild animal
Hmm.
or animal article on the specified land or part of variability thereof for transportation except after exercising due care of ascertain that permission from the state wildlife warden or any other officer authorized by the state government in this behalf has been acting for such
Hmm.
transportation.
Yes.
In this case, logic, there was this law was not followed. This policy is not followed.
Regarding what?
Regarding transportation, in public.
While it was taken from
Yes.
Assam to Tamil Nadu. But that is not the subject matter of challenge.
Another point,
It should have come up then if this was not followed. But we are on a different issue altogether.
That's how the things are started.
In 2011. Quoted to Tamil Nadu. This provision. Not followed. 2009, okay. What is it?
No person shall any wildlife, any wild animals specified in schedule 1 and 2 except as provided under section 11 and 12. So elephant is a schedule 1 animal, and lordship may come to the definition part, lordship. Section, the definition of hunting, your lordship, is section 2, subsection 16. So hunt means, lordship, is hunting with its grammatical variations and cognate expression includes subsection C, injuring or destroying any taking or injuring or destroying.
Section
16, 216, subsection C.
216.
Section 2, subsection 16, C.
Yes.
Hunting with its grammatical variations and cognate expressions includes, lordship, subsection C, injuring or destroying or taking any part of the body of any such animal in the case of wild birds or reptiles damaging the egg zone, so and so, lordship. Lordship, in this case, lordship, the things have started when the Joymala elephant, lordship, is subject to cruelty, lordship.
Okay.
Lordship, yeah, I've submitted one investigation report also, Lordship, where it has seen that the sole and the nail beds of all 4 limbs have been infected due to standing for long hours in her faces and urine, and abscess has also formed. Lordship, there are investigation, Lordship, her ear is also torn. And Lordship, they have used weapons like, Lordship, ankus were found in the Jaymala's house, where they have been beaten with those ankush, lordship.
Okay.
In the present affidavit, lordship, that the Tamil Nadu government has filed, lordship, I'll not trouble you with, lordship, I'll just read one part of a report.
Page
455. It is a recommendation by the district level captive elephant welfare committee
held on 23rd of December 2025. Lordship, in the recommendations, the following page 4.55. The following recommendation.
Yes.
The following recommendations were made by the committee, and the temple authorities were instructed to ensure their compliance well in advance of the next inspection. As reiterated in previous meetings, temple authorities were directed to take urgent steps to complete the ownership transfer and name change of the elephant as per legal requirements. And the instruction have been directed since long, Lordship. They have not complied. The elephant should be made walk daily on the dedicated mud path for exercise, covering a distance of approximately 8 to 10 kilometers. Next, at present, elephant is housed within the temple premises with a permanent shelter and open paddock having mud flooring. However, ongoing renovation works in and around the temple premises are causing disturbance and environmental pollution. These activities are restricting the elephant's daily walking routine on the mud path surrounding the temple and limiting access to the swimming pool used for the daily bathing. In previous inspections, the committee already advised the temple authority to carry out various improvement works around the elephant shelter. However, temple authorities has carried out only cleaning works around the elephant shelter and other was not carried out. Next point, Your Lordship. As temple activities are being prioritized over elephant welfare, the committee once again reiterated strongly and recommend the establishment of a new dedicated elephant housing facility with a natural ambience and adequate tree cover in nearby temple lands. The temple authorities were advised to identify suitable horticulture land in nearby areas and to shift the elephant at the earliest to ensure better health and behavioral welfare. These exercises are not been done, Lordship, since long. Lordship, coming to the Lordship, the judgments, Lordship, regarding the HPC, it has called up from the Tripura High Court, Lordship. Lordship, may take the Tripura High Court judgment. Lordship. Lordship, internal page 16, para 27, Lordship. This is the first judgment, Lordship, that the HPC has been constituted.
Yes.
So in para 27, Lordship, certain factors have been ascertained in this judgment, Lordship, which is similar to the instant case, Lordship. To our minds, the following disputed questions arise from the petitioner's allegations, albeit without material but pertinent enough to us, and allegations that must be ascertained by the authorities. If nothing, then out of caution before transporter of these 23 elephants. Lordship, these are certain disputed questions, Lordship, that has been dealt with. And finally, Lordship, in page 21, Lordship, internal page 21, para 33, Lordship. This is the outcome, Lordship. Internal page 21.
Of the judgment?
Of the judgment, Lordship.
Paragraph?
33.
Yes.
We are also conscious of the fact that it becomes difficult for the private individuals or forest and wildlife departments to take care of captive elephants for reasons of lack of manpower, finances, space, and infrastructure. There is nothing wrong in taking assistance of camps and facilities run by trust and welfare organization. However, in all cases, the paramount consideration must be the welfare of the elephants. Paragraph 34. In view of the aforesaid, we pass the following order. We direct the project Elephant Division of the Ministry of Environment so and so to issue necessary directions to all chief wildlife so and so. Lordship, may come directly to page 22, last portion, Lordship, B. Page 22, last B.
22.
Page 22. Next page.
Yes.
B,
Hmm.
the last part, Lordship. We do hereby appoint a high-powered committee, that is the HPC, under the chairmanship of Honorable Shri Justice so-and-so. We hereby appoint the following persons by designation as member of the said HPC. Director General of Forest, Head of the Project Elephant Division, Member Secretary, Chief Wildlife Officer of State of, in our case, it will be Assam and the Tamil Nadu Lordship. And the chairman of the HPC shall co-op with the expert having experienced elephant so-and-so Lordship. So this is how the HPC has been constituted and which has been upheld by the several judgments of the Supreme Court Lordship. So my concern is that I'm only concerned with the welfare of the elephant. In case Lordship, the Assam brings back the elephant, here the facilities to take care of the elephant is totally doubtful. Lordship, the elephant is there since like 16 years, 15 years. She has adapted with the Tamil language. Now, bringing back to the Assam or any place, Lordship, that may hamper the communication of the elephant. And Lordship always know, Lordship, the elephants are very sensitive elements and very intelligent. There is a high probability to become hostile also, Lordship, if some proper communications are not made. Lordship, that's why my humble prayer is that Lordship may take care of the elephant, send it to a rehabilitation center, Lordship. There are 3 rehabilitation centers in India with proper X-ray machines are there for elephants. Proper medical treatments are there for the elephants, Lordship. That is my humble submission. And the HPC is the expertise body, Lordship, who handles such issues. That is my all submission, sir.
Monto, for whom? You are who are you?
I am also an animal welfare organization.
Name.
It's called People for Cattle, my lord, in India.
Hmm?
People for Cattle in India.
Number?
9 and 10. 9 is the organization, 10 is the officer of the organization.
People for
People for Cattle in India, my lord.
cattle.
Cattle, my lord. We were impleted by the order dated 18/2/2025.
Yes.
Manoj, I adopt the submissions made by my learned friend, Manoj. I'll just elaborate on the point, Manoj. With regard to the HPC, my lord has seen the judgment passed by the Honorable Tripura High Court. Thereafter, the Honorable Supreme Court, in the matter of Murli, had expanded the jurisdiction pan-India, my lord. And Bindra had again, my lord, later clarified on the remit of the HPC, my lord. Now, in terms of Bindra's case, my lords, the remit has been extended to monitoring the facilities for transport and the need to shift elephants, my lords. So, my lords, in my humble submission, since there is a expert body, my lords, I pray, my lords, that this matter may be kept pending, my lords, and if it can be referred to the HPC to have their opinion first. Why I say so, my lords? If any order is passed by this honorable court, my lords, directing the transfer or transportation of Joymala, my lords, since this court may not have the expertise, my lords, it may be against the welfare of the animal, my lords. Now, my lord, another aspect, my lord, with regard to the temple, my lords, we had already offered the temple a mechanical elephant, my lord. I'll just read out one paragraph from the IA, my lords. The applicants beg to state that by letter dated 1/6/2023, the applicants communicated to the Commissioner Hindu Religious Charitable Endowments Department, Tamil Nadu, wherein applicants suggested to gift a mechanical elephant to the Sirivili Puttur Andal temple. It is to be noted that the mechanical elephant looks exactly like a real elephant, but never gets hungry, thirsty, anxious, hurt, lonely, or angry. The purpose of the said communication dated so-and-so is to provide the mechanical elephant so that Joymala or Jayatimala, as she is called, would be sent to either Wildlife SOS Radhe Krishna Temple Elephant Welfare Trust or Wildlife Rescue or Rehabilitation for permanent rehabilitation. We've already offered.
What is a mechanical elephant?
Well, mechanical, because since these elephants are used for spiritual purposes, my lords, they need not have a real elephant, my lords. The mechanical elephant looks just like a elephant. It can mechanically walk, move, my lords, and it is only for the purpose that it can be decorated and taken out for processions, my lords. In fact, that has been used. If my lords comes to the second paragraph, the applicant begs to state that replacing real elephants with mechanical elephants would also be in consonance with the decision of the Honorable Madras High Court, Madurai bench passed in so and so. The mechanical elephant can be made a male or female and can move its head, ears, tail, and lift its trunk and bless devotees and spray water as and when required. So all the purposes for which an elephant is used in the temple can be solved by mechanical elephant, my lords. And we have already offered the temple that we can give you a mechanical elephant if you let Joymala.
You already gave.
Now, there's a letter, my lords, we offered. my
Offered.
lords. That is
You offered to give a mechanical elephant to the temple.
Temple.
Not accepted.
Not accepted.
No response rather.
No response. No response. My lord, lastly, a matter was also filed before the Honorable Bombay High Court, my lords. When Bombay High Court? Yeah, my lord, the Bombay High Court had relied on a magazine called Parents Patriarch, my lords. May I read these very important, my lords? Just one paragraph from the Bombay High Court judgment. Here, what had happened, my lords? The HPC had directed that an elephant should be transferred from one place to another. That was challenged by the temple which was holding the captive elephant, my lords. So what was held by the Honorable Bombay High Court, my lords? Paragraph 9. I'll furnish a copy, my lords. I just have one copy. Before we part, we deem it appropriate to record that we have considered and chosen the survival of the elephant and its right to quality of life over and above the rights of men to use elephant for religious rights. We have no doubt that the petitioner may have had no deliberate intent to cause injury to the elephant. However, in the given circumstances of conflict between the rights of an elephant and the rights of the petitioner to use the elephant in discharge of its religious activities, priority must be given to the elephant's welfare. The court has duty under the doctrine of parents patriae to secure the rights of the voiceless and hapless Mahadevi, the name of the elephant, my lords. We cannot but reminisce the words of Lawrence and Anthony in his book, The Elephant Whisperer. Perhaps they quote a few lines from a book, my lords. It's paragraph 9 of the judgment. So in my humble submission, my lords, if the matter can be referred to the HPC, which also has powers to take suo motu cognizance, my lord. If my lord peruses the judgment, the Murli judgment, it would appear that the HPC also has powers to take suo motu cognizance, my lord. So it will be in the best interest of Joymala if it is first referred to an expert body, my lord, before taking any decision on whether she can be transported back to Assam or can be sent to a rehabilitation center.
Which paragraph you read? You read 9, paragraph 9.
Paragraph 9, my lord. My lord has the judgment. Paragraph 9. So I humbly pray, my lord, this aspect may also be looked into. That, in my humble opinion, would be in the best interest of Joymala. We're only concerned about the welfare of the elephant.
Okay, yes.
Intervener lordship, I have a limited submission lordship. I know we can intervener.
You have finished, Mr.
Yes,
Don't
lordship,
do-
but I have no objection towards the ownership. of the
Mr.
unit, lordship.
Das, installment arguments are
Yes,
not
lordship.
allowed, not encouraged at all.
But
So you
this-
take your seat, you have done it. Yes,
No,
Mr. Naik.
ownership is not in dispute, lordship. I'm not objecting to that, lordship.
Mr. Naik.
Lordship, attempt has been made by the respondents, Lordship, to
Hmm?
divert the issue. The basic issue we have raised is the illegal captivity of an animal, Lordship, beyond the permitted date by another state, Lordship. That is the basic issue. If Lordship comes to page 24, Lordship, of my writ petition. 23,
23.
yeah, of the writ petition, Lordship.
Yes, you have shown this.
This is the ownership certificate
Hmm.
issued under section, 42. Now, this has been issued by the state government. Next page, Lordship will again see page 24. This is the permission given by the transportation certificate. No objection certificate for allowing entry of domestic element in Tamil Nadu. By the state government, Lordship may kindly see the last column, period 3 years. Next page is, it is by the Tamil Nadu government, Lordship, accepted. No objection is hereby accorded as per guidelines of so and so to transport the elephant named Jaimala from Assam to Nachir Temple, Tamil Nadu. So everywhere the period is mentioned.
Yes.
If Lordship comes to page 28, then Lordship, page 28. Page 28 is the affidavit filed by one Sri Green Moran, Lordship. He is the registered owner, Lordship. On 12/10/2011, just one day after the so-called gift deed was which was relied upon by the respondents, Lordship.
Yes.
This is the affidavit. And if Lordship comes to page 30, page 30, small Roman 3, that I have not sold or transferred the ownership of my aforesaid elephant to any person. He is not authorized also. 5, Roman 5, that I shall recall the said elephant after 3 years. Now, Lordship, after expiry of that 3 years period, Lordship, it was the duty of the Tamil Nadu government to return the elephant. It was not done. Accordingly, the requests were made by the state government, and ultimately they give it their NOC. They consented that yes, we are returning the elephant, which facts was not specified before the Madras High Court, Lordship, when that PIL of 2022 came up for hearing. It was subsequent, Lordship. Initially, the NOC was given. Thereafter, Lordship, that undertaking was given before the Madras High Court. So therein, Lordship, before the Madras High Court, Lordship,
yes,
these facts were not mentioned. And most interestingly, Lordship, Tamil Nadu High Court, Madras High Court never issued any direction. In fact, the issue is before this honorable court as regard illegal captivity of the animal by the Tamil Nadu, state of Tamil Nadu, Lordship. That is the issue before this honorable court. So this honorable court will decide whether the elephant has been kept illegally or not, Lordship. Now, if Lordship comes to the law, Lordship, we have page section 39. Section 39, Lordship, 39A.
Wildlife Protection.
Wildlife Protection Act, Lordship. Every wild animal other than vermin, which is hunted under section 11 or subsection 1 of section 29 or subsection 6 of section 35, or kept or bred in captivity or hunted in contravention of any provisions of this act, or any rule or other order made thereunder or found dead or killed or by mistake, and I'm skipping the other portion. If lordship comes to the next page, shall be the property of the state government. Now, lordship, if lordship section 39 and section 40 and section 42 conjointly lordship, ownership certificate is given only in respect of a state property lordship. The elephant which is under of the state, ownership certificate is given to the owner lordship just because it is under his captivity lordship. So that is the law. And if lordship comes to
What does it specify, the ownership certificate?
Ownership certificate is as per section 42 only.
You no, so 23, what is the expression used in at page 23?
Page 23 is the certificate. This is as per section 40 lordship. Custody or possession of the following animal. Page 23 lordship.
23, please read.
It is hereby certified that Sri Girin Moran, son of so-and-so, village so-and-so, Tinsukia, Assam, under his control, custody of possession of the following animal articles of his, etc. This is the animal lordship. Animal, domestic elephant.
So this is under which section?
Basically, it is under section 42 lordship.
42.
Yes. It is mentioned there, lordship. Rule number 58, section 42, top.
See, elephant has to be treated, cannot be treated in a generic way, because unlike any other wild animal, elephants have been domesticated since long.
Lordship.
So, elephant per se cannot be said to be only wild elephant. Elephant can be
If lordship
domesticated.
comes to section 40 lordship, that
Yes.
declaration.
Yes.
This is in respect of those animals, lordship, which were in custody prior to coming into effect of this act, lordship. So a declaration is required.
Yes.
42. No person shall, after the commencement of this act, acquire, receive, keep in his control, custody or possession, sell, offer for sale, or otherwise, this is important, lordship, otherwise transfer or transport any animal specified in Schedule 1. Animal is mentioned there, Schedule 1. Elephant is mentioned there. Schedule 1 of Part 2 of Schedule 2, or any uncured trophy or meat derived from such animal, or the salted or dried skins of such animal, or the mask of a masked deer, or the horn of a rhinoceros, except with the previous permission in writing of the chief wildlife warden or the authorized officer. So this is the authority, lordship. That is how has become authorized by the state government to prepare this writ petition, because it was under his authority. The
No.
I'm coming to that.
No. Yes, it's not on that case. That is not the argument.
No.
The authority to do this is nothing to do with the authority who will institute a writ proceeding.
That is the explanation given by the petitioner, lordship, in his affidavit. That is why I'm coming to my alternative argument also, lordship. I'm presenting, lordship. So that is one, lordship. So for transportation, lordship, it is the approval of the permission of the authority is necessary. So under that authority, lordship, permission was granted and the elephant was transferred to Tamil Nadu for a specific period, lordship. And after the expiry of that period, lordship, they should have returned the animal. They did not. Accordingly, process was initiated by the state government. Ultimately, they issued the NOC, but subsequently they denied.
How is it transported? Just as a matter of fact, by road.
That's specific. I have to.
How is it transported?
I think it is by road, lordship.
Any idea, Mr.?
No idea. No idea.
That specific instruction.
You're dealing with the transportation and elephant, you don't have any idea. How will the court have an idea? By road, probably.
could be elephant or after all. And it was adult at that very point of time. 7 years ago, because elephant lives up to 100 years of age.
We are taking instruction. Because they are the-
Normally, how is it transported?
By road. বললাম যে এটা তুমি গম না পাবা কেনেকে পঠিয়ালে ওনারেহে পঠিয়াই দিলে তাকো দিবলে So that is one aspect, Lordship. So far as the limitation part is concerned, they have issued the NOC only in the year 2022, Lordship. You issued NOC in the year 2020. Now you are saying that it got lapsed 8 years elapsed. You cannot raise it. At the same time, you cannot take both the arguments. Either you have waived or it is barred by limitation. If Lordship takes my affidavit, Lordship, affidavit in reply, Lordship.
Yes, please.
At 411, page number 411. Three paragraphs are important, Lordship. Paragraph 5.
Just a minute. What are these photographs from page 108? Annexure 2 onwards.
এখন তোমার ঘরে ধ্রুপদ ধ্রুপদ এটা মান্দি আছে না
Once there is a activity lordship late idea. These are the pictures, your lordship, that it has been changed in a small area lordship. The part of the investigation lordship that we have conducted under section 50, subsection 1.
27/7/2022.
Is there any SOP or guidelines how you keep a domesticated elephant? First, whether a domestication of an elephant is permissible.
Wildlife protection and that is part of. Because elephant is scheduled and again and again in the provisions of the wildlife.
No, it can be done with permission, that you cannot just read like this. If it can be transported, it can be.
At page 34, Lordship, one guideline is there.
34.
I read it, my lord. I pointed this out. I read this part.
Mhm. No, from reading of the guidelines, it is presumed that you can domesticate, it can be domesticated.
Even that permits. Wildlife
Hmm.
Protection Act also permits.
Which one, where?
My lord, section 42 itself, my lord, indicates that certificate of ownership. Likewise, section 40 also is an indication of that. Followed by section 43, captive animal. The very definition of captive animal is bred in captivity. What is bred in captivity is domesticated. And 43 subsection 2 with proviso speaks of transportation of captive elephant.
Animal,
Huh?
not
Captive,
elephant.
captive elephant.
Where?
43 subsection 2 proviso.
Proviso.
43 subsection 2
Okay.
proviso.
For religious, yes. We have read it out that provided that the transfer or transport of a captive elephant for a religious or any other purpose.
Likewise, my lord, in section definition clause, section 2 subsection 5, while defining captive animal, it speaks of animal specified in schedule 1. The schedule 1 is elephant.
Elephant is also there. But conditions have any conditions been prescribed by the central government so far as proviso is concerned?
That will not. I tried to find out. I couldn't lay my hand on. State of Tamil Nadu has made its own rules under 2000.
That you have. That you have. Yes.
If Lordship comes to my affidavit, Lordship, page 411.
$411,
11, Lordship.
Yes.
Paragraph 5, Lordship. As regards to the statements made in paragraph 3 and 4 of the additional counter affidavit, the deponent denies the same and most humbly begs to submit that the instant writ petition is maintainable in its present form as the issue pertains to refusal to return the elephant Jaimala back to the state of Assam by the authorities in the Arulimogud Nachir temple. It will be pertinent to mention herein that the issue in the writ petition does not pertain to any dispute between the two states of Assam and Tamil Nadu, as has been projected by the respondents, but limited only to that of illegal captivation of the elephant Jaimala beyond the permissible period, that is 17/9/2013. In the Arulimgu Nachir temple, Tamil Nadu. The question as to ownership of the elephant Jaimala is not an issue required to be decided in the present petition. In such circumstance, the state of Assam being the owner of the elephant Jaimala, who has been kept
I
illegally.
think this should be 17/9/23. What was it?
That is the permission, Lordship, for 3 years.
Permission, 79,
NOC granted for
2013.
3 Yes, Lordship. Lordship
13.
has- yes, 2013. Lordship has perused that document,
Yes, yes.
Lordship. That is at page 31,
Yes.
17/9/23.
Hmm.
The question as to ownership of the elephant, Jaimala, is not an issue required to be decided in the present writ petition. In such circumstances, the state of Assam, being the owner of the elephant Jaimala, who has been kept illegally by the Arulimgu Nachir Temple, Tamil Nadu, and the authorities in the state of Tamil Nadu refusing to facilitate her return. A writ petition is maintainable before this honorable court, and the same does not warrant institution of an original suit before the Honorable Supreme Court of India under Article 131 of the Constitution of India. Next paragraph, Lordship. As regard to the statements made in paragraph 5 of the additional counter affidavit, the deponent denies the same and most humbly begs to submit that the petitioners in the writ petitions are authorities of the state government in the ranks of Principal Chief Conservator of Forest and Chief Wildlife Warden Assam, who have been duly appointed as per provisions of Section 4(1)(a) of the Wildlife Protection Act 1972 for the purpose of performance of his duties and exercise of his powers by or under the said Act. As the matter involves an issue under the domain of the Wildlife Protection Act 1972, and being a matter of immense importance for the state of Assam, the then Principal Chief Conservator of Forest Assam, who continued to function as the Chief Wildlife Warden by notification number so-and-so dated 10/2/2022, and being authorized under the Wildlife Protection Act 1972 to facilitate the return of the elephant Jaimala, was competent to represent the state of Assam as the writ petitioner of the instant petition. Further, under the relevant provisions of the Assam Rules of Executive Business 1968 and amended thereafter, the Principal Chief Conservator of Forest and the Head of Forest Force Assam is competent to swear the affidavit, and in this regard, the deponent reserves the right to make appropriate.
Can we have a deliberation on some elaboration on Assam Rules of Executive Business 1968?
Yes.
That the state can be represented by the PCCF.
Yes, that is so far as executive rules of executive business are concerned, Lordship, that has been specifically made who can file a writ petition on behalf of the
Not
state.
LRC, state by PCCF, unheard of.
Lordship, on this point, Lordship, I have other submissions also. On this point, Lordship, one provision I would like
Since
to.
they have mentioned this rules of executive business, we wanted to have a look.
Yes.
How does it, where does it provide that a PCCF can
Lordship,
represent the state?
one provision, Lordship, I would like to place, Lordship, that
Yes.
is Order 1, Rule 10 CPC, Lordship. One provision.
Order on Rule 10 CPC,
Yes.
for what purpose?
Lordship, I'm coming to that. If Lordship looks at.
No, we know what 110.
Lordship, that this principle was followed by this honorable court also, Lordship, wherein initially Deputy Commissioner filed a writ appeal, Lordship, on behalf of the state, and subsequently on filing an application, Lordship, court allowed to, addition of appropriate authority, Lordship. That option is
110
open.
is a different aspect altogether. How does 110 deals with competence to represent
Lordship,
the state?
One Lordship. Yeah, right, okay. Right, okay.
No, since you have fallen back on the rules, that is what we wanted to.
No, what I am saying.
We have in your pleadings, you have stated that you would be saved by Assam Rules of Executive Business 1968. Which part? Can we have a look? This is not going to help you. This is only an addition of parties. We wanted to know from this 68 Rules of Executive Business, how the PCCF, there may be, we do not know, kindly enlighten us on this issue.
No, my submission will be, Lordship, even if it is not covered by the rules of executive business, Lordship.
No, you have written in the pleadings.
Yes.
That is what we are.
We file a affidavit, Lordship. So considering the importance, Lordship, issue is very important and very serious, Lordship. So that opportunity may be granted, Lordship. If Lordship looks at the provision, Lordship, or Order 1, Rule 10, Lordship, once, Lordship.
No, not PPC.
Order 1, Rule 10, Lords.
Order 1,
Rule 10.
yes, please read.
Suit in the name of wrong plaintiff or non-joinder and misjoinder of parties. 1 says, sub-rule 1, no suit shall be defeated by reason of the misjoinder or non-joinder of parties, and the court.
Mr. Nayak, kindly read 141, if you have not read earlier. Section 141. Of the CPC.
Lordship.
You have the CPC before you. Please have this.
Sub-rule 2 is important. Lordship.
Please have this. Before you make a submission, you should at least know what is the CPC, what is this kind of proceeding, what is 141. Please read the entire one, including the explanation.
Yes, Lordship. That is why I have placed the, in that judgment, Lordship, court said,
No, we
although
cannot say something which is not provided in the statute.
Lordship,
Statute has specifically excluded CPC from writ proceeding. We
Lord-
apply the spirit. That's a different
Lordship,
matter.
view taken by the division bench is that although this is not applicable in case of writ proceeding, Lordship, principles can be adopted, Lordship.
Principles is
And
applicable.
on that basis,
That
Lordship,
is a settled law,
Yes.
but that is in a different context. You file an application to change your cause title to be represented by the
Yes.
secretary. That
That-
you have not done here.
yes, you have
So
not
can
yet
that be a
done-
defense? Then when this has been raised, issue has been raised, give us a chance.
Yes, Lordship. At this
This
stage,
is
Lordship,
not-
it has not been preferred.
It's
Lordship,
not been done.
that opportunity may be granted.
So 110 is a different context altogether.
Lordship. Lordship, that principle was in fact.
This has been specifically raised by the learned senior counsel.
Lordship.
We have to answer that. If you had not raised, matter would have been different.
Lordship, in that situation, Lordship, Lordship will definitely appreciate that it's a seriousness or a matter of
The
seriousness.
matter is serious.
I'm praying for some time then, Lordship. Lordship, let me make an appropriate application, Lordship.
After hearing the matter,
At any stage, it is possible, Lordship. If the principle is to be followed, Lordship, at any stage.
any stage means what? After hearing?
Any stage of hearing, Lordship. Lordship, in fact, one of my senior colleague was there in a matter, Lordship, in that matter, Lordship, where when I was preferred by the state government, Lordship. Initially, it was by the deputy commissioner. Subsequently, commissioner was, I mean, the government
Secretary, or the joint secretary,
Yes, Lordship.
or the deputy secretary.
Yes. Under,
General process.
under secretary or.
And even rules of executive business. You have mentioned this wrongly, perhaps. That's why we wanted to have a look. It's a pink color book, small book. Rules of executive business.
I have the executive business, Lordship. I am aware, Lordship, that somehow that statement was.
PCCF, we do not think that is there. If it is inserted, it cannot be inserted.
Not there.
PCC is not a secretary of a department.
Under secretary and above, Lordship. Not head of the, under secretary and above. That is clear, Lord. So far as,
So what is your,
so
what is your,
these
fine-
days, Lordship, I'm praying for at least 1 week time, Lordship. Let me file an appropriate, application, Lordship. I think that will be necessary, Lordship. And
yes, what do you say, Mr. Senior Counsel, who is online?
Well, as far as this is concerned, it is not there for the first time. When I argued before your lordships today, I have raised that issue. But if your lordship will come to my affidavit, if your lordship will have give me that page.
Page 403.
403, if your lordships have my affidavit, they had an opportunity, but they said, no, it is not necessary.
Yeah, you said that you brought this on record by filing an affidavit on 5/8/2024.
No, that is in regard to the judgment millers. Now, if your lordship, will have-
Even otherwise,
if your lordship will have page 405 millers, this is my.
405.
My affidavit dated 9th September 2025, paragraph 5. Assume, your lordship have got that, Miller?
Yes. Assuming it, but not without admitting.
Assuming without admitting that the writ petition by state of Assam is maintainable against the state of Tamil Nadu, it is not instituted by a proper party. Principal Chief Conservator of Forest cannot maintain a writ petition purported by the state of Assam. In terms of section 79, section 80 CPC.
19 September 25, you could have filed a rejoinder.
To that rejoinder, they say is competent.
They don't say that, no, 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 I will make an application and make the chief secretary to file a fresh petition. Because at this-
The
because
matter is
hearing again,
serious.
because at the end of
On
the
this,
hearing.
on
at
this ground, we don't
stage-
want to oust.
Technically, my other friend is correct.
He's correct.
With regard to the nature of the.
Yes,
litigation,
yes.
I think that liberty should be given to the state. They find an IAS.
That is what we say on the importance of the matter, but he's entitled to say, raise this issue and he's raised it in a very,
Our perspective is, my lord, with effect from 11-10-20, 11-10-14, my lord, this elephant could not have been there. It's illegal, contrary to the provisions of the act. It was taken for 3 years. Now, what is that way? What is the locus of the, my lord, temple to insist on all these things? Well, yes, that's a technical plea. PCCF is not a government. The government can be represented by under secretary, deputy secretary, joint secretary, etc.
secretary,
etc.
yes, yes.
That I think state will take care. But otherwise, my lord, and
The issue is
moreover, in
important.
terms of the Honorable Supreme Court's order, my lord, prayer which we are making is within the domain of the HPC, my lord. For a moment, if your lordship would kindly have the Supreme Court order.
No, we have seen that.
Yes, well, I'll just read
It has been
paragraph
placed
5,
before
my
us.
lord.
It is placed before us.
Para 5.
Murali case, Murali.
No, my lord. Prerna
Bindra,
Singh Bindra.
Bindra, the subsequent one,
If
Bindra.
your lordship would kindly have para 5, my lord.
Yes, we have. Good, good. Bindra Singh Bindra, yes.
Para 5 at page 9. Gopal Shankar Narayan Senior Counsel submitted. As a lordship.
Yes.
Yes. That the remit of the HPCs would also cover the following aspects. Duration of ownership certificate in relation to the elephant. Inquiring into the capacity of the facility where the elephant are proposed to be transferred. Monitoring of the health and age of the elephant. Monitoring the facilities for transportation. They need to shift the elephant. So the prayer which we are making, my lord, is within the, my lord, contours of the power of the HPC. Now, whether he should be retained, how, in what manner he should be transported. In any case, my lord, the permit was for 3 years, and 3 years have expired long back on 11-10-14. So that way, my lord, under the provisions of the act, the stay of the elephant at Tamil Nadu is wrong, my lord. Assam government is bound to bring it back, my lord. Or in the interregnum, my lord, considering the other aspects, I think the HPC should be given a role, my lord. Let them take a call on the health and all these aspects, my lord.
I think we grant a week's time first
My lord.
May I
to
make
the
one
state.
submission? If your lordship will permit me, may just.
Yes, please,
1 minute,
please.
May I make
Yes.
one submission, let's.
Yes, please.
Now, would your lordship look at page 20?
20.
20. What is the scope of the petition? I don't understand how a respondent can enlarge the scope of the petition or set up a new case different from what the petitioner has pleaded. What the petitioner wants is a very specific thing. Petitioner wants an mandamus from your lordship directing the state authorities in the state of Tamil Nadu in facilitating the return of the elephant to the state of Assam. I fail to understand some respondents how they set up a new case and their own case. If they want some other relief, they should file their own petitions. Would you like to look at the prayers as to
Yes,
why a written
yes.
mandamus could not be issued?
Yes,
Respondents
yes, yes.
they
We'll
don't want-
we'll consider that.
they don't want the elephant to be sent to some rescue home or etc. etc. State of Assam wants the elephant back with them. I don't know how a respondent can set up a different case, different from what the state. If they,
Yes, okay.
they think
Heard.
something else should be done.
Okay,
they-
okay.
Reply to my learned
Okay,
friend
okay.
next.
Yeah, let him first. Heard Sri P. Nayak, learned AAG for the petitioner, state petitioner. For the petitioners, also heard Sri P.K. Tiwari, learned senior counsel, representing the state of Tamil Nadu. But the Union of India is there?
Yes, yes.
H. Gupta is there, Lordship.
Is he there in the court? Mr. Gupta? Record your name for CGC. Sri H. Gupta, learned CGC. Sri K.N. Chaudhary, learned senior counsel assisted by Sri D.J. Das for the
Respondent number 8.
8 and Sri P. Mohanto for respondent numbers 9 and 10. Sri so learned senior counsel assisted by, you have a local counsel here?
Yes, Malaysia. Is there?
Yes, by so for the respondent number 11, correct?
Yes, Malaysia.
11, full stop. Though the in the course of the argument, comma, an objection has been raised by the learned senior counsel for the respondent number 11, questioning the competence of the principal chief conservator of forest and HOF Assam to represent the state, which was also raised in the additional affidavit in opposition. Full stop. Though an explanation was sought to be given by the state in its rejoinder affidavit, comma, Sri Nayak, the learned counsel, has submitted that he may be allowed an opportunity to file an appropriate IA for proper representation by the state. Full stop. Para? Considering the importance of the matter involved, this court is of the view that interest of justice would require giving an opportunity to the petitioners to file appropriate application in this regard, as dismissal of the petitioner on this ground may not serve the interest of justice. Full stop. Para? In that view of the in that view of in the above conspectus, matter is adjourned by 1 week.
Not.
1 week, by which time appropriate IA may be filed. We give a date. There's an opposition counsel. List on. Yes, you will be appearing online only, so no difficulty as such, isn't it?
Yes, Malaysia.
Yes, list on. Today is 17th. We can
Come up on 23rd or 25th.
on 26th.
Your Lakshmi, as far as the last week is concerned, Malaysia, that week I will be in Sikkim, Malaysia. Your Lakshmi either keep it earlier or your Lakshmi keep it after the 5th of April, Malaysia.
Okay, then we'll have it on 7th of April.
Very well, Malaysia.
7th of April. 2 weeks time.
7th, my lord, I would be in
And
the
once they
permanent
file
bench.
that
Election
application,
petition.
Malaysia,
You'll be in?
On 7th April, my lord, there is election petition in the permanent bench, Itanagar. So
when?
witnesses will be coming, my lord. I have to
Okay,
process that.
tell us when.
Then, my lord, it could be, my lord.
It's only an IA. It's only an IA.
I think for that purpose,
The hearing is not done, my lord, on that.
Hearing will
day,
not,
IA.
only we'll
it
consider
will
the IA.
27th, my lord. Only that.
27th March.
No.
That week I have a problem. Malaysia.
27th, Senate Council.
24th. my lord.
24th, can you file it by 24th? That week he is not there. We can have it on 31st.
Well, let it be 9th of April. I'll be here also.
Yeah, then the election as well.
9th of April,
Oh,
you
election,
will
sorry.
come.
I forgot. Election. Election.
Okay, then we can have it on 31st.
Okay.
31st.
31st. 31st, is it okay?
31st, Malaysia, that week I am in Gangtok, Malaysia. It's a part-time matter there
No,
before.
that week starts from 30th.
30th.
We can have it in the week
Anytime
commencing
earlier,
from
26th or 27th?
Anytime after that, Malaysia, I have no difficulty.
26th. 26th. Thursday.
26th March is a,
26 is in Sikkim.
Thursday.
is it? 26th March is a Sunday.
26th March.
Very well, Malaysia, 26th March is all right. I will,
Thursday.
I will do it, Malaysia.
Okay, 26th March.
Malaysia, liberty to file a reply to that application, Malaysia, they serve it to me on time. Otherwise, on that day, I will have to make the request.
Okay,
They
first
give it
let
to
him
me-
file.
If they give it to me earlier, I will file it. Otherwise, on that.
Okay.
Not in case I'm not there, my lord, my junior will be there, since only IA.
No, you already indicated that he'd like to file an objection.
Very well.
We cannot restrain him from filing an objection. Okay.
Then there's no problem.
We thought you would dispose this off.
Extremely grateful to your lordship for the patient hearing.
It's okay.
Lordship, I keep this started then.
No, not parted.
Of that.
থাকক নোটখিনি থাকক ইন কেছ যদি আহি যায় মোৰ তাত কাৰণ বহুত ফৰেন হৈ যাব এই তাতে থব নালাগে এইখিনি বহুত নোট আছে তো মোৰ তাত এইখিনি খালি বেলেগ এখন হেৰি কৰি নম্বৰটো কিমান
6107. 2022.
এলিফেণ্ট কেছ এইটো বেলেগকে থৈ দিওঁ এইবিলাক তাতে থোৱা চব compilation today. Compilation, we are returning to the local council. You can hand it over on the back. But hit to the end. File to it. You can have it here. You can have it here. Oh, CPC con. CPC on Anilo. Yes. Next.
Item 7.
Your Honor, today looking for short accommodation, date may be fixed. There is some difficulty on our part. We have already filed a reply to the objection filed by the
We have give a date on a request made on behalf of the petitioner.
April 1st week of
Matter is adjourned to be listed when?
first week of April.
On first week, it will be motion date. First week, we can have it on 1st of April.
1st of April.
1st of April.
Much obliged.
Item 1 and 2 pending.
On to time, I guess. Which one?
Item 1, your Lordship, may take. This has all the facts.
5943.
Later in point of time, this has all the papers. But this matter has a long and checkered history. Facts are pretty long. If your Lordship permits me, I can briefly summarize the facts.
Yes.
That way it will perhaps make it easier for all of us. Now, what had happened was, there was a road construction contract way back in 2008 that was awarded to the petitioner. It was a reasonably long stretch of road. Just after a few months of commencing the work, this is in that Hosai Lamding area. There was a lot of disturbance in and around that area. Lots of issues cropped up. There were miscreants who started snatching away machineries, threatening the laborers. So continuously over a period of time, I lodged FIRs, I approached the superintendent of police, I approached the district administration. In fact, the officers concerned, the concerned executive engineer, he also wrote to the police authorities.
Yes.
However, suddenly, and they were fully aware, the authorities were fully aware of the ground realities. And naturally, the work fell a little slow. Suddenly, out of the blue, I get a show cause notice. And I submitted a detailed reply indicating all these facts, which were, in fact, very much part of the records. Most of them. They pass a very cryptic, and in fact, it is the executive engineer. I'll place for the contract that it is actually that power is conferred on the chief engineer. The executive engineer terminates my contract. This happened, the termination happened on 3rd of December 2012. There is a provision for a dispute redressal mechanism in the contract itself under clause 24 of the GCC. I submitted an application under that. They kept it pending, and while this was pending, they liquidated my performance security, etc. They approached the bank, my performance security was liquidated. Under these circumstances, I filed a writ petition.
First one, 2511.
No,
251.
there was this is already disposed of.
Okay.
WBC number 377 of 2013. This was disposed of with a simple direction that my application that is pending under clause 24 be disposed of. Based on this, within a few days,
Your application under clause 24 for under the dispute redressal mechanism.
Absolutely. The chief engineer passes a cryptic order without even recording my taking note of the grounds taken in my application. Very cryptic order. He rejects this application. Against this, there is again a provision for appeal under clause 24.2. I preferred the appeal. And just a few days after that, filing the appeal, I come to hear from various sources that what they have now done is they have split up the work into 4 different components. And they were in the process of awarding the contract. I submitted an RTI application, no response. And that is when I filed the next writ petition, which is before your lordship, 2515. This writ petition also has a very interesting history. WPC number 2515 of 2013.
Yes.
Here, the challenge was twofold. My termination itself was under challenge. And the NIT that I had heard of, the so-called NIT, I had heard from certain sources that there is a tender process. So both these things were put to challenge.
Yes.
Here, the commissioner of PWD filed an affidavit that also I'll place for it. It is part of the records in this petition. He filed an affidavit saying that there was already an NIT published in 2 newspapers, one called the Assam Post and the other one called Aji.
This matter was heard by this court long time
A
back.
similar matter. I had appeared where there was manipulation with the advertisement. And
Yes, yes.
On this issue, the facts are very similar. Now, the commissioner filed an affidavit.
But this is very similar.
Yes, yes. In fact, I had appeared for one of the respondents.
Borbhuya or something. What was the name of the case? Borbhuya. or something.
Yes, one. Some Borbhuya. In fact, your lordship was pleased to direct an inquiry in that.
Inquiry, yes, yes, I remember.
Once this affidavit comes, the commissioner files a very simple affidavit saying that we had initiated a tender process, published it in these 2 newspapers, and we have in the meantime finalized the tender process and awarded the contracts to Mr. X, Y, and Z. Based on this affidavit, this honorable court was pleased to arrive at a conclusion that now that the fresh tender process has already been finalized, your only grievance that remains is with regard to your termination. So this appeal may be disposed of. Now, once this order was passed on 26/6/2013. Now, once this is passed,
yes,
we ultimately came to know that these NITs where we approached the DIPR also, we came to know that these NITs were not even published. And he had also taken up a stand that I had already disposed of the appeal. I'm sorry, well, the original clause 24 application, and after doing that, this NIT was published. Now, once we dug further, we realized that firstly, it was an out and out false statement saying that I had already disposed of the application, and after that, the NIT was floated. That the dates itself themselves will indicate that this fact was also a false statement made. And the second fact that it was published in 2 newspapers was totally false, because just as sample to keep it in the records in 1 copy each, they had shown it to have been published, and that was kept in the record, and in the main issues that were actually circulated,
It was not there.
not there. So we filed a review petition. In the review, all these things came out, and they ultimately went to the extent of admitting these facts. And the blame was entirely put on a superintending engineer. That superintending engineer was suspended, and they claimed that this was he was proceeded against, etc., etc. Now, once all this hangama got created, they come up with the next, which is impugned before your lordship. They say that now we are going to impose damages on you, since you did not complete the work on time. They somehow, I was never put to notice. They come up with their own calculations and say that I owe to the department a sum of 1 crore 11 lakhs odd. And the other thing, mischief they do, and this is, the dates themselves will indicate that this was absolutely in a vindictive manner, because I filed the review, and in the review, they were completely exposed. What they do is they not only say that it is behind my back, I am entitled to pay 1 crore 11 lakhs odd. What they do is, some works that I had executed, completion certificates that were issued long back, 2005, 2006, they have withheld all of that money in the name of recovering this amount. So that is the action that is under challenge in this writ petition money. So in a nutshell, and ultimately, my lord, a criminal contempt was drawn up against the commissioner. The review was allowed. That is how the other writ petition is before your lordship. The writ petition was restored back to file. Against the initiation of criminal contempt, they went up in an appeal. In the appeal, the rest of the judgment in review has remained. The only thing, to the extent of, because he tendered an apology, based on that apology, he was exonerated. And in a nutshell, this is the matter before your lordship. Now, if I may take your lordship through the documents. First, your lordship may kindly turn to page 27. This is the work order. This is dated 30/9/2008. Pursuant to your furnishing the requisite performance security as stipulated in ITB clause 32.1 and signing of the contract of so-and-so. 1, Mozadar Gaon number 1 so-and-so, 2 so-and-so. There are 4 different components, in fact 5 different components of the road construction. And
Mr. Chaudhary, response number 7. Perhaps not take up.
I'll leave it to you.
Though long time has passed,
Yes.
there's nothing, but still then.
But now, otherwise, he has retired, and we are also not pressing anything against him.
Or let it be by us.
I'll leave it to you, Lord.
Mr. Gogoi, before any other bench. What is happening today after hearing matters? Again, 2-page notes.
It's just that your lordship may perhaps, since it's a very old matter, your lordship may perhaps like to indicate.
As the writ petitions are pending since long, registry may list the same before any other bench expeditiously.
I can read.
Item 8.
May I please, Your Lordship? Land of the father of the petitioner was acquired, my lord.
Lordship, in this case, my lordship, we have filed our affidavit, but from the affidavit record will require lordship. Because they have disputed that no objections were given. In our affidavit, lordship, page.
But you had consented that we can take it this for disposal at the admission stage.
Lordship, on the affidavit, lordship, page 34, lordship, it is in that at the time of disbursing the entire share of amount, the petitioner father, all the formalities were observed. And on objection petition, hearing was also taken from the other legal heirs of late so-and-so, where they stated that they have no objection if the compensation is awarded in the name of respondent number 6. That's why, lordship, what was the no objections they given, it was not there. That
Petitioner-
upon their objection,
When can you get the records then?
Summary.
After the vacations now, lordship,
23 matter.
lordship, after the vacations now, the
It is in Kamrup district, my lord.
Kamrup district, but lordship,
Heard 3 H.R. Ahmed Learned Counsel for the petitioner as well as 3 S.S. Roy, Learned State Counsel. Full stop. Para. 3 Roy, the Learned State Counsel has submitted that though affidavit in opposition has been filed by the respondent number 2 on 15/9/2023, comma, the relevant records may be necessary to be produced. Full stop. He accordingly prays for some time to obtain the relevant records. Para. In that view of the matter, in that view of the aforesaid submission, the matter is adjourned to be listed on, we'll have it immediately after the vacation,
lordship, 23rd,
on 22nd,
lordship,
22nd is a Wednesday.
lordship.
Obliged.
Item 9.
Yes. 4:30, अभी 3:30 हुआ है। इतना जल्दी। Yes.
The file seems to be heavy, but the issue is very small.
Okay, let's do it.
But Sraf is not there.
Oh, you're taking time.
Next week.
What is the issue involved, Mr.?
What happened, they are claiming on the basis of SRT nutrients, that judgment has been held to be parenquarium by subsequent judgment. They are claiming exemption on basis of that.
They are claiming what?
Exemption.
Exemption.
Education says and the higher secondary says. SRT nutrients said that they are entitled, that is not a part of.
Which one says? SR?
SRT nutrients.
SRD nutrients, okay.
Subsequently, it was held to be parenquarium by unicorn judgment.
Unicorn he had placed earlier also.
So their case is that since the refund was quoted by on the basis of their judgment, so they are entitled. Our contention is that
Yes,
Yes, next week any details.
but this proposition.
Lordship may fix another.
Okay. The prayer for adjournment has been made on behalf of Dr. Saraf, Learned Senior Counsel for the petitioner. Also heard 3 S.C. Kyle, Learned Standing Counsel, CGST, who submits that the issue is covered by the judgment passed by the Honorable Supreme Court in the case of Unicorn.
Unicorn Industries.
Unicorn
Industries. Unicorn Industries versus Union of India.
reported in
Reported in 2023 SCC 492. 2023 SCC page 492.
2020.
Notes.
2020 3 SCC 492. Full stop. Para. Be that as it may. Matter is adjourned to be listed on 21st April, after the vacation.
Then Lordship, yes.
21st.
23rd.
23rd, okay.
Because I'll be in 21st, I'll be in Itanagar.
23rd.
Notes. The interim order that may be continued.
Interim order passed earlier to continue till the next day.
Notes.
I think 10 lordship, the one affidavit filed by the respondent number 4 lordships.
We have seen that. That was filed last year,
Lordships.
22/5/2025. Yes, we have seen that.
Paragraph
But who is for the petitioner?
petitioner, Mr.
M. Khan.
Lordship, M. Khan. My lord, they have been allotted, my lord, dock number 162 and 283 by the SLDC. But entire land lordship near about the 61 bigger 3 kata 13 lessas, they are enforcing.
Hatipota daily market under Dhubri Jilla recover running purely.
Lordship, in our affidavit, paragraph number 3, 4, 5, and 6 lordships we have been stated clearly.
You are contending that apart from the area of 9 Bigha, there has been encroachment of adjoining areas.
Lordship.
And to those encroachers, you have issued notice.
Lordship. And they are asked Lordship to submit the documents. My lord, they are unable to produce any document. Lordship may kindly see the notice.
Then we can say that let there be a proper demarcation of the area, whoever is outside.
Even then, after my lord that SLDC proposed my lord that allotment, my lord that never my lord meted their name. In our lordship, in our affidavit, we have stated one
Okay,
lordship
okay,
guideline.
we'll grant another opportunity.
Lordship.
None appears for the petitioner. Petitioner is on call, whereas the state is represented by the Hendik, J. Hendik, the state council, and the footstep, Miss Ann Bodler, learned standing council for Revenue Department, and Miss P. Thapa, learned council for Priyas Datta, learned standing council PNRD, are also present. Para, in the interest of justice, matter is adjourned to give the petitioners another chance. List on 24th of March. Yes.
On next day, my lord, the anniversary will meet. My lord,
Let him, if he doesn't come, we might
Lordship, your lord,
dismiss.
The interim order is there, the status quo.
May I please, Lordship?
No, we'll not be that liberal. In absence, we'll extend the interim order. We have not dismissed, that is more than enough.
Even then, they, I think, my lord, the interim order not continue.
Yes.
Lordship, item 11, Lordship. My
Mr.
lord,
Priya.
in this case, my lord, respondent number 5 file affidavit, my lord. And here affidavit saying that till today, the missing file has yet not traced out. The issue involved, my lord, my name, my lord, cancel in the mutation order. That is page, my lord, 21, passed this illegal order. And when I come to know through Horitri online, my lord, and I file a RT application. Then what way my name has been cancelled. And therefore I sought entire record pertaining to the miscase number, mutation case 66 to 2021. And they could not provide the necessary document, therefore first appeal.
You have filed the
finally second
affidavit
appeal
today,
also filed.
madam.
But respondent number 6 copy has not provided. Respondent 6.
If I don't copy, I cannot post. Somebody made it.
But I have not received the copy.
And
Can we? But on record, copy is not. Oh.
no, it is not.
Acha, in the morning hour, it is not available.
Mr. Bhuya has perhaps not received this.
Yes, Lordship.
Maybe my.
No, he has not served upon Mr. Bhuya.
Oh, copies are.
There is one GSM, one for Arcade Talukdar, one for SC Revenue. These are all respondents, but the petitioner has not been served. Just check. Just check. Check it. Right, sir.
Or it pays provide now also, I can receive. I think the
Yeah.
copy is there.
Madam. Just check. The main person has not been served. And you have given an undertaking that you have served. It will be in difficulty, madam.
Respondent number 6, no?
What about your undertaking? Nowadays, you need to have an undertaking, even if you serve, even if you do not serve. You have to be careful. Do the respondent number 6 has filed an affidavit on 10/3/2026. It appears that copy of the same was not handed over to Sri K. Bhuya, the learned counsel for the petitioner.
Now receive.
Miss M. Bormon, learned counsel for the said respondent number 6, has however served a copy of the said affidavit to Sri Bhuya in the court. You want to file a rejoinder?
Lordship.
Sri Bhuya, the learned counsel for the petitioner, prays for some time to enable him to file a rejoinder affidavit. Okay. Rejoinder affidavit. Sri, your name? Sri S.R. Alam, learned counsel for the respondent number 7, has also prayed for some time to file affidavit in opposition. In that view of the matter?
Any date?
And in that view of the aforesaid submissions, the matter stands adjourned by 3 weeks to enable exchange of further pleadings.
Lordship, date may be fixed.
Would you fix a date? List on 3 weeks, it will be after the Bihu then.
Lordship.
We can have it on 24th. Is it okay? 24th April.
Lordship. High level.
4 weeks. 3 weeks in 4 weeks.
Item 14.
Hey, Islam. Yes, where are you?
Please, Your Lordship, this is item number 13.
Possible for the time being. Mr. Sharma is in legs for it.
Your
You have
Lordship,
filed some affidavit. Who has filed affidavit?
Your Lordship, respondent number 5 has filed an affidavit in this case. Your Lordship, we seek some time to go through that affidavit. Your Lordship may have it next week.
Okay, we'll have it next week. Okay.
Please, Your Lordship.
What is your name? What is your name?
Please, Your Lordship, my name is Ishan. I'm appearing for counsel for petitioner Karan Bharadwaj.
Heard Sri Ishan. What your surname?
Please, Your Lordship. Mahajan, Ishan Mahajan.
Ishan Mahajan, learned counsel, appearing online for the petitioner, who has submitted that the copy of the affidavit of the respondent number 5 has been served upon him only yesterday, and he prays for some time to go through the same para. Matter accordingly stands adjourned to be listed on. We'll have it next week.
Please, Your
Is it
Lordship.
okay? Next week. On 25th. No, 25th March.
Please, Your Lordship.
Okay. Yes, Miss उनका नाम लिख दीजिए. S. Yasmin, learned counsel for respondent number 5 is present.
Should be, here I said that architecture is a petitioner side advocate minor, probably Mr. Bhuya has not accepted such fact.
But Arki Talukdar is NH.
His name is shown as for the petitioner side in the cause list. Maybe some mistake, but some endorsement is.
Arki Talukdar.
Some other person maybe.
Arki
Same.
Talukdar. Wakala Namasa. Where is Mr. Bhuya?
I'm just informing you.
No, let us see. Last word. Wakala Namasa. What's the name?
After the normal city.
Call Mr. Bhuya.
Which is.
We thought we saw Arki Talukdar. We thought Arki Talukdar is for NHA.
That is why I'm also confused, but after verification of cause list, then I come.
Is he there? No. This is unfair. He pointed out on the next date. We'll deal with this matter.
Wait, please, Your Lordship.
Yes.
The minutes were confirmed.
So,
Yes, Mr. Talukdar.
Lordship, that proposal from the review committee was not accepted by government. And it was returned back for re-verification. And
But have you informed the petitioner?
Next meeting is on 19th of this month, day after tomorrow. There it will be re-verified.
Lordship, the consequence of this has been that he has been incarcerated for a full 1 year. The proposal was sent in 24,
25.
23/12/24. Lordship. Meeting is of 25.
24/6.
Where is the rejection?
No, that has not come, but it says it will be placed before the next meeting. That is scheduled to be held on day after tomorrow.
The statement has not accepted recommendation. 4/6. When is the next meeting? Day after tomorrow.
Day after.
Okay, then let us see what happens day after tomorrow.
Right.
Heard. 3A Atreya Learned Counsel for the petitioner.
Next meeting.
Pursuant to the directions of this court dated 25/2/2026 and 9/3/2026, 3 BJ Talukdar, additional senior government advocate Assam, has placed before this court written instructions dated 13/3/2026, as per which the recommendation of the state level review board taken in the meeting dated 24/6/2025 has not been accepted. Full stop. He has, however, the said instructions also, said instructions, however, reveal that the next date for the state level review board has been fixed on 19/3/2026 to re-examine the matter and also to consider fresh proposal. Full stop. Considering the aforesaid development, the matter is adjourned to be listed on 20th of April 2026, on which date the minutes of the review committee be placed before this court.
Obliged.
Mr. Atreya, we can also challenge that rejection
Yes, sir.
or incorporate this, the challenge in this petition.
In this petition.
We want to see what are the reasons.
Yes, sir.
At least you can file an affidavit, then we can ask them to have the reasons placed on record.
Yes.
Hello, sir, item number 10. I was on the traffic.
10 we have passed orders. We have not dismissed, but it'll come after some days. Okay. Next.
16.
Lordship was pleased to issue notice. My learned friend was supposed to file affidavit.
Here in this case, maintenance issue is there also. So today it is not possible otherwise. Maintenance issue is there.
Would you like to file an affidavit raising the issue of maintainability?
I place the judgment of the.
Okay, then.
Otherwise, my lord, the tribunal is not functioning. Only one member is there.
Tribunal is functioning, lordship.
Only
and
one
lordship,
Well,
Lordship
will
court
we?
is also going on, lordship. Regularly, the division bench, district court from the Bombay bench is going on, lordship. There is no difficulty, lordship.
We'll hear it and whenever you say. When?
It's for lordship. It's for lordship.
After
I heard
25th.
3A Goel Learned Counsel for the petitioner. Full stop. In this case, notice was issued on 2/3/2026. Full stop. On the 2/3/26 and on the same date, comma 3K Gogol and CGC had raised a preliminary objection questioning the maintainability of the writ petition, as there is an efficacious alternative remedy in the form of a statutory appeal under the Railway Claims Tribunal Act 1989. Full stop, para. Sri Gogoi Dilana CGC has submitted that the aforesaid issue be taken up before going to the merits of the challenge. Full stop, para. As agreed to by the learned counsel for the parties, list for admission on the aspect of maintainability on which date?
After 25th, any date, my.
On 31st?
31st.
31st.
Interim order mechanism.
Interim order passed earlier to continue till the next day of listing.
Deep.
Item 23, is
এটা আছে আৰু ইয়াতে পুৰণা হিয়াৰিং আছে নে ল'ব লাগে 33
Let's say paragraph 4 and 5 and 6 of my affidavit may be seen on that basis. Let's say this may be
covered.
not covered. Not covered. What happened? Let's say initially.
Your affidavit, when did you file it?
was
You
filed-
filed on 27/10/25. What have you said in 4, 5 and 6?
Paragraph 4 stated that the first sentence, the order was passed stopping the claim of the petitioner and that was accepted by the department. Subsequently, another so-called notice was issued,
Yes.
but he didn't appear, so executive authority passed the order. The amount and the period is same.
Okay. Now,
What's it? Because on same set of facts, same set of figure, already one proceeding has been dropped, my lord. And second proceeding was issued. Our contention is that in spite of issued notice, they said that they have not received. But the executive authority has no option but to proceed with the issue.
but first issue having been dropped,
But it was not pointed out to the executive authority.
what was not pointed out?
Earlier, there was passed with the same period. We didn't file any representation. What's it, paragraph 6?
But now he is in the court.
Yes, Lordship, that may be considered.
But you cannot have two proceedings.
Yes, correct, Lordship. But our defense is that in the second proceeding, they didn't appear and didn't file any written submission.
No, when your jurisdiction is challenged to issue initiate, wasn't it within your knowledge that the proceeding, more than him pointing out,
No, Lordship, why?
you may be correct in contending that he should have come up immediately and said that you cannot proceed.
Yes, Lord.
But
That's
for
our
that,
contention.
okay.
Otherwise,
Heard Sri R. S. Misra, learned counsel for the petitioner. Also heard Sri S. C. Kyle, learned senior standing counsel CGST Full stop. Considering the facts and circumstances involved, and also and as agreed to by the learned counsel for the parties, this writ petition is taken up for disposal at the admission stage. Full stop. Para. As per the facts projected, the petitioner is engaged in the business of goods transport agency service, which is covered under entry so and so. It's enough. It is covered under so and so, under notification so and so. Full stop. It is contended that in terms of the said notification, the petitioner is not required to pay service tax, and rather the service recipient is liable to pay tax at the rate of 100% on the value under reverse charge. Full stop. However, the respondent number 4 had issued a show cause notice dated 22/10/2021 for the financial year 2016-17 for an amount of rupees 61,76,335/. On receipt of such notice, the petitioner had submitted his reply along with documents. Full stop. The respondent number 4, after considering the same, had dropped the proceedings vide an order in original dated 30/3/2023. Full stop. However, vide an order in original dated 23/8/2022. Full stop. However, the grievance of the petitioner pertains to another show cause notice dated 30/3/2023 issued by the respondent number 5 confirming demand of service tax of rupees 61,76,335.35. Full stop. It is the case of the petitioner that the impugned order dated 30/3/2023 has been passed for the same period and same figures pertaining to the earlier notice dated 22/10/2021, which had culminated in the order in original dated 23/8/2022, whereby the proceedings were dropped. Full stop. Sri Mishra, the learned counsel for the petitioner, has submitted that the impugned course of action is wholly without any authority of law, apart from being unreasonable and arbitrary. He has submitted that once the matter was adjudicated and the proceeding dropped vide the order in original dated 23/8/2022, another proceeding could not have been instituted based on the same period and same figures. Full stop. Para. Sri Kyle, the learned senior standing counsel, by referring to the affidavit in opposition filed on 27/10/2025, has however contended that the petitioner, in spite of receipt of notice of the present demand, never appeared and filed his reply. Full stop. He accordingly justifies the action. Full stop. And accordingly justifies the action. Full stop. The Sri Kyle has however fairly conceded that not disputed the aspect of the earlier show cause notice, not disputed the aspect of an earlier proceeding initiated by the show cause notice dated 22/10/2021 for the same period and same figure. Full stop. This court is of the considered opinion that merely because of the fact that the petitioner did not respond to the subsequent show cause notice culminating in the impugned demand, the same will not grant power, authority or jurisdiction upon the respondents to initiate another proceeding on the same period and same figure, inasmuch as the earlier proceeding had culminated in an order in original dated 23/8/2022, whereby the proceeding was dropped. Full stop. In that view of the matter, this court is of the opinion that a case of interference is made out. Full stop. Accordingly, the impugned order dated so and so is interfered with and stands set aside. Writ petition stands allowed.
Item 17 for adjournment.
15 matter itu পুরোনা itu করে হবো. Yes.
This matter may be taken on another date.
No, this is a 15 matter.
Lordship, what happened, my senior SG Borua, my name is also not there, my lord. She went to the Arunachal at 0 code, lordship, but because of weather, she could not reach Gauhati on time.
15 matter, can we adjourn, grant an adjournment of a 15 matter? Tell us.
Last on Thursday, lordship.
What is the matter, Mr. Gogoi? He had made a request for adjournment in the morning. We declined.
They are
Is it-
basically asking for a de-reservation of a reserve forest a lot. So, and that they're harping on a communication, it's interdepartmental communication, which gives them no right. And in the meantime, the Forest Conservation Act came up. The
There's hardly any scope of adjudication.
Although after going through the record, my lord, as per order dated 2/5/2024, my lord, directed to Revenue Authority to file affidavit, but till that no affidavit was filed, lordship.
But can your prayer be accepted? How can you de-reserve a reserve forest after coming into force of the Forest Conservation Act?
exactly. Lord.
The restriction is so much. It is, and it will be against the interest of public. The emphasis is on afforestation, and you are asking for de-reservation.
The main contention is that the 30s have been issuing letters. So the main contention is that depending on that letters and that communication, this petition is filed. But administrative order letter doesn't give them a right to lordship.
Where is that letter?
Various letters that they have annexed to lordship. At page 48, your lordship, this one letter.
48.
48. Reservation of the Terracotta Reserve Forest. This is by the Secretary Government of Assam Forest Department. And it was issued in 1986, your lordship.
Not 86, 66.
66, sorry, 66. Then page page 61.
What was the USF?
USF is
Unreserved social forest or what?
stands for
Unreserved social forest land.
social forest.
But this was a sanction. Governor's sanction was there. Acceptance of proposal.
You know, the affidavit where Meena said very clear, lordship. The affidavit the department has filed, your lordship.
What have you stated?
They say that the proposed diversion of 15,000 bighas of forest land by government letter dated 1/12/1996 was never executed as fresh inclusion of 15,000 bighas of USF land, was never handed over to the forest department. Para 5, page 2 of the affidavit in opposition, lordship. At para 8, we have stated that although the reservation process was going on, but the forest reservation process of 15,000 bighas of USF land was never initiated. In fact, at para 28.
Okay, when? Tomorrow?
On Thursday. Hearing matter, Lordship.
Thursday, Thursday, okay, Thursday. A prayer for adjournment has been made on behalf of Miss H.G. Barua, S. Gohai Barua, Learned Counsel for the petitioner. Three petitioners also heard Sri R.R. Gogoi, Learned Standing Counsel Forest Department. Para considering that this writ petition is pending since the year 2015, while the prayer for adjournment is declined, a short accommodation is granted, directing listing of this matter on Thursday, 19th. Okay, rest. Yes, there is one more matter. Madam, your matter. Oh, company petition. Today you're lucky, my time will not permit, but we are not going to adjourn this matter. When? Tell us.
Your lordship may have it on.
It will assign nahi kiya, madam. Assigned nahi. So assigned hoye na. It will cover bill account notice. Yes. What did you say? After we would, it doesn't look good. See, matter is of which year? Just see. 2015 matter. We have to make an endeavor.
Your lordship will have it on Thursday in that case.
Thursday we have fixed matters. Thursday it will be listing for just for the purpose of listing. We can have it on 24th.
24th.
Yes. Paucity of time, huh? 24th. Okay. Rest, court master will give dates. Any matter where interim order is still today?
Lordship, there is an interim order in item 21.
21?
1.
21. Okay. Dated already, interim order. Okay.
Alia.